So I'm very happy to welcome you on the behalf of the organizers at the conference on directions of political reforms in societal bills of the Association of Polish Judges IUSTITIA. You see the agenda. That conference is composed of 3 blocks. So first we will discuss a new case model, and then a case weighing system, and we will discuss also all these issues related to the new judges. So all these issues are important to restore in Poland rule of law. It is important for us to determine the trend of really guaranteeing the judiciary independence. Now let me give the floor to the president of the Association of Polish Judges IUSTITIA, Professor Markiewicz. So, distinguished Marshal, Minister, President of the European Judges Associations, distinguished colleagues, the topic is about restoring rule of law, briefly. And for me, it is of crucial importance that we are meeting here today at the Polish Parliament, because this is the place where so far we could just criticize some things, usually without any effect, or possibly we could be crying close to the Senate or Sejm, where something wrong was going on. Now the situation has changed, and I'm very happy with it. So we are here where the 3 constitutional powers meet. That is the legislative power, the executive power, the judiciary power, and what is important, we have also representatives from Europe. This is how collaboration between the powers must look, which is provided for in the preamble of the Constitution. So there should be such collaboration so that Poland is a strong state of the European Union. I'm very happy that at the conference and throughout our common path, we are not alone here among all these powers. We have here colleagues, representatives of the civic society, representatives of other professions. We have here prosecutors, solicitors, advocates. There are academia representatives, other representatives of the Codification Committee. There are legislators, and your help throughout all these years has been of great value. So we know all what the 15th October is, that is the election in Poland, and restoring the hope to rebuild rule of law. But such things, after these long 8 years, I mean, restoring rule of law is not happening just in a very short time. We, as the Association IUSTITIA, started working on draft legal laws several years ago. For 2 years, we've been working more intensely on that. At the beginning, the activities were carried out in cooperation with the Public Codification Committee that was set up after the first Congress of Polish Lawyers, which was the reaction to all the wrongs that were happening. So it was Chairman Wojciech Popiołek, Professor, and Professor Jakubecki were in charge of these activities, and they are now here with us. So I'd like to thank everyone from this sort of social codification committee, and I'd like to thank all those who contribute to the creation of the committee institutionally for many years. So these were legal counsels and advocates. We have here with us the president of the National Legal Council Chamber, Professor Hruścik. So I'd like to thank you for all these years of cooperation, especially for the last dozen months or so, where the help of the best legislators who are here with us today was really invaluable. So, ladies and gentlemen, we prepared the package of several bills on the judiciary on the system of common courts of law on the National Judicial Council. So under the package we have the law on the Supreme Court of the Prosecutor's Office. We have representatives of Lex Super Omnia, the bravest association of lawyers in Poland, and they prepared their draft bill on the public prosecution. We have also on the laws on the Supreme Court and the Constitutional Tribunal, which is now being processed in the same. So the fragment of that law is being now debated in the Senate. So I'm very happy that we have such an opportunity and that we are back to normal. We all here, Mr. Minister of Justice, Professor Adam Bodnar, Mr. Marshal Macieja Żywno is here with us as well. And we can rely on their help, not only as regards the opening of the discussion, because it opened, but in order to aim at defining the European standard and what would be best for Poland, so we could process it in the Polish Parliament. So I'd like to thank you once again for coming. And if I may, I would like to ask the co-host of the conference, that is Mr. Marshall, to take the floor. The floor is yours. So, ladies and gentlemen, on behalf of the Marshal of the same, Madam Kidawa-Błońska, the High Chamber of Senate, and also the ladies senators here, we are very happy to welcome you here in the building of the Polish Senate. For us, it is really a great event. We appreciate that you accepted our invitation to come here to our building to discuss justice, I mean, with respect of its restoration. And this is very difficult, not only for lawmakers, but for the whole society and those that had to grapple with the law. And with Judge Markiewicz, as we were born in the same year, we entered the period when Poland was leaving the communism, and then we saw how it was becoming mature later on. But we do remember the last years of the communism, so our children will learn about it from schools. And my son, who is a student of law, who I thought that as regards of the lack of the rule of law and the abuse of the law and legislature, these topics would be taught him from books only. But unfortunately, the last 8 years, he saw it in reality. Not only he was taught about it at the university, he also saw that his father had to grapple with the consequences of not being a member of the ruling party, which is really inadmissible from the viewpoint of the rule of law. Hence, the today's political situation in Poland gives rise to very positive emotions to me, but very sad emotions, because we are discussing the restoring of the rule of law or not further development. So that's sad, because in 2024 in the European Union, in a democratic Poland, we would definitely wouldn't like to go back to the situation where we have to restore something. This is really extraordinary. But today, as I've mentioned today in the morning, we are more optimistic. We hope that indeed, because of that situation, we would create a very robust legal system. I'm saying this because I've been working for the state, central administration and local governments, and I had positive associations with the Association of IUSTITIA, because together we provided a training to NGOs so that they would better register their organization. Then I wouldn't think that in a dozen years or so we would look at the Iustitia Association and the judges' self-administration as a fight for rule of law and fight for the position of judges and law in Poland. When I thought about cooperation with the district court, then as voivod of Podlaskie, I was in competition with the president of the court in Podlaskie as regards computerization of courts, and I met the president of the court. I wouldn't name his mention because these are delicate matters. We were then on the train and we were discussing that a dozen years or so we would not believe that we would discuss development, even technological development of state institutions, but we would discuss the return to the roots. But there is one good thing in it. Please treat it as a sad joke. I mean, citizens in Poland paid attention very much to Constitutional Tribunal and National Judicial Council, because before that KRS was associated with the registration of businesses or associations, because that is the same acronym used. So now we are in a situation where we are mature to understand that objectivity, independence of the judiciary, of judges is so important, and we have to defend it like we have to defend our independence. So while I'm welcoming here at the building of the Senate, I would really confirm that the two committees on rule of law is working on the amendment of KRS law, and the president started working on the constitutional law and the constitutionality of law. And what is important, I think, the senator and the whole chamber here, especially those members who are from the coalition of the 15th October, would emphasize that nothing would be going on without your participation, without your experience, substantial experience, because it should not be politicians who should create the legal system. We must do it together. Thank you so much. Ladies and gentlemen, today we see how the situation in Poland changed in the last month, because this event is organized by the representative of judges, and that is the judiciary, also legislative power, and we have also a representative of the executive here, that is Minister of Justice, Mr. Adam Bodnar. So, ladies and gentlemen, distinguished guests, thank you so much for inviting me to the conference, for giving me opportunity to say a few words at the very beginning of the conference, and for giving me opportunity to take the floor in the afternoon to make a speech. Let me start with a small recollection. I remember that in July 2017, in this conference room, the Committee for Rule and Human Rights and Petition of the Senate was working here. They were working on the law on the Supreme Court adopted by the Parliament in July. That was this kind of famous law which provided for the retirement for the judges of the Supreme Court, except for those named by the Minister of Justice. I remember we were here debating in this conference room, and I was here with the manager of the committee, lawyer Wróblewski. So I remember when we were debating, so I remember that the citizens here were protesting. They were saying that the senator, you still can do it, and they were singing songs, and we felt this civic energy, and it lasted for a few days, and then there was the debate in the Senate, and then Stanisław Zabłocki, the Supreme Court judge, said about free courts, that free people will remember free courts, and this became the slogan which is symbolic for Iustitia, and it was later on printed on official T-shirts of Iustitia. So I remember that the atmosphere of that days and this civic protest, not here close to the Senate, but also in front of many courts all across Poland, gave this energy for judges to protest for being involved in various proceedings before the court in Strasbourg, especially in front of the Court of Justice of the European Union. So that was really one of the most important moments. That was July 2017. If it had not been for that, we would not be able to meet here today and to discuss the restoration of rule of law. We would still be very much discussing these elements of non-democratic systems. So we are lucky to meet here at the international conference, which is supported fully by the Senate of the Republic of Poland, as Marshall said, and myself as the President of the Executive. I do say that at the same time we have the expose of the Minister of Foreign Affairs, who says that restoring rule of law is one of the priorities of Poland's foreign policy also, and regaining trust of other countries of the European Union and international organizations, restoring the importance of multilateralism in our foreign relations. At the same time, we receive here the Venezia Commission here, and it's not received as an unwelcome guest, and for whom really would not be given a kind of business card. No, it's treated as the proper international delegation who wants to help us, who advise us, maybe even criticize some solutions on the law of the National Judicial Council. So it's interesting that we are meeting today, and at the same time we are hosting various international organizations of judges, bringing all judges from all over the world, and all these organizations were very active in the past. Also the March of the 1,000 Gowns, and through very lively contacts, one of the great friends of ours, the Judge Keesa Sterka, is with us, and I remember how he was really given a farewell when KRS was still an independent institution many years ago. I think we should remember about the context of the venue of the historical moment. Thanks to it, we get energy for further activities. I think that we have not wasted the last months, because first and foremost, we created all instruments to restore rule of law. First and foremost, the Parliament became again of the venue of meetings, debates, and today's conference is the example of that. That was one of the first decisions of the government to set up the team for restoring rule of law. And thanks to a very intense cooperation, I would say, even thanks to the fact that I can have a kind of duet with Maciej Berg, Minister, we can step by step prepare various draft laws. The Ministry of Justice has a department who's supervising the whole legislative process. It is headed by Director Gubała, and Judge Mazur is very well known to all of us, and he's responsible for all these issues. And finally, Codification Committee for the State and course is created, and Judge Markiewicz is the head of it. And I think that we have many members of this Codification Committee for the court and public prosecutor's system. So it seems that paradoxically, being a general prosecutor may help restoring rule of law. Today, the case is now ongoing in Warsaw, where the competences of Prosecutor General are quite useful, not to mention now the mode of making complaints to various chambers, not only the chamber of extraordinary control. So the issue all of great importance, because I think that now at the end of April we are technically organizationally prepared but also determined to move forward. And I think that everything that was done by the civic society organization, what was done by Iustitia, is great material for further work, and I'm very happy that this energy and the substantial knowledge and experience and first of all specific texts of laws could be used in the further legislative process. Yesterday we saw that was the first reading of the law on the Constitutional Tribunal, which was prepared by the group of experts headed by the Batory Foundation, but this is the draft supported by 48 NGOs. So this is the project which will be publicly heard soon. That's how it looks, because we are thinking about that happens when we introduce difficult solutions. So there are many changes to be introduced. We started with the National Judicial Council, and the Senate committee will deal with it, with the law on the Constitutional Tribunal. There are other laws now in the Parliament, that is the law on the common courts of law. Soon the government would work on them. We are having debate of the Supreme Court on the status of judges appointed by KRS after February 2018. We in fact prepared the draft law separating the Office of the General Prosecutor and the Minister of Justice. Soon it will be dealt with the government, and then it will be subject to public hearing. But the reality brings additional events which show that we have to deal with other maybe issues which were not traditionally part of the package of restoring rule of law, but are necessary, such as supervision of secret services, including increasing the role of courts and instruments of courts to exercise supervision of secret services. Ladies and gentlemen, I of course do realize that the legislative process does not have guarantees of the positive finish in each and every case. So there's no guarantee that even if you made a great effort in the Parliament, the NGOs will make such effort, the public debate, and we will have the ideal solution. But finally, there might be some precedent argument at the end, which will lead not to adopting the law. But it doesn't mean that we don't have to work out the best solution, and it does not exonerate us from the responsibility of drawing conclusions from those 8 years where successively the Polish rule of law was destroyed and democratic institutions were being eroded. Maybe the whole legislative process culminated with a positive finish will take a bit longer, but it doesn't mean that we have to stop somewhere in the middle of our way. We just the opposite. We have to work hard, and I'm happy that today's conference will contribute to that. Thank you so much.
Dziękuję bardzo za niezwykle ciekawe.
Thank you very much for this very interesting introduction. Thank you to Marshall, to the President. As the Minister said, we are still held accountable, and we need to be accountable because for the last couple of years we've been working as judges in order to prepare our courts and to give them back safely to our citizens. So let's move on to the first part of the conference, a new model of administering courts. So I'm giving the floor to the facilitator of this part of the debate. Thank you very much for giving me this role of moderating this part regarding the model of administering courts in the light of standards of the rule of law. So we've invited to this panel Dr. Katarzyna Monika Florczak-Wątor from the Jagiellonian University, from the Department of Law. She is dealing with interdisciplinary studies, and she has published a series of works on this subject, and she is also a member of the National Chamber of Legal Advisors in Krakow. And in this panel we will also have a judge, Professor Katarzyna Gajdy-Roszczynialskiej, who brings together all those perspectives, which is being a scientist at the Faculty of Law at the Silesian University, but she's also a judge in Krakow. The judge is also a member of the Chamber of Prosecutors. And our other guest, Professor Keesa Sterka, a professor from Maastricht University, a judge of the Supreme Court, a former judge of the Appeal Court. This first panel will be dedicated to a new model of administering courts. We are having here to deal with two perspectives. First of all, we need to strengthen the administration of courts because there is a huge need of rebuilding the judiciary. This is on the one hand. On the other hand, speeding up court proceedings in order for a fair trial to be executed. And both can be implemented only if this administration model is reviewed. So I'm giving the floor to Professor Katarzyna Gajdy-Roszczynialska. Good morning, ladies and gentlemen. I have a great pleasure as a judge, as a scientist, to be here with you in this excellent venue of the Senate to discuss the shape of the Polish judiciary. As we all know, the last years, those have been the years of a fight for the rule of law. But now we have a unique opportunity of restoring the rule of law, of rebuilding the judiciary as such. So my task for today is to present what we consider is something which is a modern administration system that would be efficient and that would take into account the citizens' perspective. So the starting point here for this discussion is something that was already prepared by our Social Codification Commission. And now it's become a legislative initiative, social legislative initiatives. Those are social drafts of laws. So let me introduce this term, which will be introduced for good, which is the administration of courts, of the judiciary. So administration of courts is a set of practices and institutions that refer to the judiciary that are here to regulate and make it more efficient for the judiciary to act and to apply the rule of law in specific cases. So simply speaking, we can say that as concerns this aspect, it concerns all the competences aiming at making it more efficient. So the second aspect is adjudicating by the court. This is another aspect. There shouldn't be such a confusion. Those competences include personal competences, administrative, financial, education, related competences, ethical, informative competences, regulatory competences, and they have a great impact on the whole judicial system. So now we are getting to the core subject, to the problem that has to be dealt with. So far, we've had a model of administrative supervision over the judiciary. It is rooted in absolute 19th century monarchy, where the executive supervises and administers the judiciary. This concept was based on the fact that the power is not fully legitimate, so the executive has to administer. And this was done because we wanted the state to work in a more efficient way. But the paradigm has changed recently, and the judiciary is now to be for the citizens. It has to be open to the citizens. So this administrative competence within between this competence is a secondary competence. The new paradigm of a court, as regulated by the European Union, supposes the existence of a court which has a jurisdiction power which will guarantee the execution of the rule of law. So it is natural to organize the administration of courts that would give us such guarantees, such possibilities. In order to implement this paradigm, we need to withdraw from the 19th century paradigm. So a new system, administration system, needs to be implemented. Executive powers have to be completed by creating a new modern system. What are the options at stake? I will not enter into detail about the already existing models in Europe when it comes to administering courts. There are 4 models. Councils, ministries administer all kinds of dedicated administrations in order to administer courts are created, but of course there are many different variants which are rooted in some countries, and they're really rooted in their history. In Israel, for example, what really counts are directors of courts, in fact. And in the US, the system is totally different. So what to choose so that we guarantee all this to our citizens? A starting point is to appoint a specific entity that would administer the courts. So their independence is important, the independence of those entities. They shouldn't be linked to any political parties. So what are the conclusions? The system of administering courts have to be changed, and they shouldn't be linked to the executive power. So if this organ, which is the most competent one in the system, is, for example, the Judicial Council, so then it's important to introduce a specific law on the Council of the Judiciary. So we have had some draft laws, and we assumed that the most competent entities in order to complement all those administrative functions in the judiciary, this would be the Council of the Judiciary, National Council of the Judiciary. What decided about it is the fact that it worked efficiently, it would work efficiently and would implement all the rules of law, rule of law respecting EU standards. So we considered that this entity should be efficient and based on transparent criteria. The lack of those criteria will always lead to some irregularities when it comes to the exercise of administrative powers. We extended administrative competences of this council, and those competences are specified in the draft of laws. This model, ladies and gentlemen, should look like this. As you can see, it should be apolitical and efficient and open to citizens, which will be guaranteed by legislative solutions in this draft. Competences of the executive power will be limited. It will be apolitical. The council will be apolitical. We are talking especially about appointing judges, for example, but also the functioning of this council, and financial aspects also have to be taken into account. The efficiency, transparency, those are the rules that will be applied here. because it will be regulated by the law. The competences of the Council of the Judiciary that will allow to have an impact on the judiciary in a way to guarantee its efficiency. We will be introducing new administration methods, weighing cases, and a map, access map to the judiciary, evaluation systems, and so on. And we would also like to introduce some ethics rules, which already exist, of course, but we would like to extend them, and they are not fully regulated. So we will also like to implement something that is functioning already in other countries of Europe, is the Good Practices Code. Code of Good Practices. This is not only about how a judge should act, how he should behave in the courtroom, but it's also about having some kind of guidelines on what practices are efficient in the work of a judge. Being oriented towards citizens, there will be a new social council. Within this social council, there will be representatives of all corporations. This is guaranteed by the law, not only barristers, notaries, but also other lawyers will be part of this council. And we are introducing two institutions of
tego, aby Rada komunikowała się.
The Ombudsman of the Council, who will be responsible for contacts with the society, but also the spokesperson of the judiciary. This is the institution that we introduced because it's necessary to have a good communication with all our citizens, between courts and citizens, at all levels. So we assume also the existence of a plenipotentiary for international affairs, and we will be also working more with the sectorial representatives, and the obligations of the Council towards the society are a huge part of this accountability element. Without the accountability, a properly working council couldn't fulfill its functions. It will become legitimate only and solely when their activity is well understood by the society, was well communicated to the society, and only if their activity is accepted by the society. The acceptance by the citizens, this is really a key thing for any administration system. Courts are not courts for judges, they are courts for which function and work for our citizens. So the basic assumption in our project, in our draft, is that strengthening, rebuilding a new system supposes the reform of the Council of the Judiciary. So within this draft, part of the competences will be on the side of the courts, and some of the competences will be also with the Ministry of Justice. What has to be stressed here is that the panel of this judiciary, Council of the Judiciary, is different than in other EU countries. The Council of the Judiciary gathers not only judges, it's half of its composition are judges, and half is other representatives of some other authorities. So the composition of this council makes the administration of courts possible to all the parties involved. If you look through the standards introduced by EAJ and OSCE, so you can see that our regulations are in line with all those standards. If there are some differences, and those differences are in minus, which means that we have a constitution which regulates the composition and the appointment procedure, and there's some constitutional framework that needs to be respected. So that's why there is this slight difference between those standards and our constitutional rules. It's obvious that for the Council to work properly, it has to work with the authorities, not only national authorities, of course, the legislative and executive power, but it's also about local authorities, working with them, with local authorities at local level. This is where we would like to extend information obligations of the Council to allow for such a cooperation with local authorities. As regards the competence of the executive power, it will be like acting together they will act together, the Council and the Ministry of Justice, within the competences of the Ministry of Justice will be all the judiciary strategies, EU funds, Privatization Commission, and all other legal professions, all the competences regarding international cooperation and large competences regarding minors and family cases. So this will be the only competence of the Ministry of Justice. When it comes to regulating the position of the Council towards other bodies, we've adopted that the first sine qua non condition to be fulfilled is to restore constitutional standards regarding the appointment of the members of this council. In the draft, we assume that judges should be, of course, appointed by their peers, by representatives of judges. But, of course, we are of the opinion that in order to have a full representation as regards common courts of law, which is in line with our law, binding law, the appointment, the choice is free, regardless whether we are at district or regional level. We can choose a district, regional, or appeal court judge. We are free to do it. There are no strict rules, because there is the status of common court law judge, in fact. So we do not make a link between a court level and a given judge. It's in line with the OSCE recommendations from 2023 and gives us full representativity of all the types of courts. In the draft, when it comes to in census from which level those judges are, we implement Warsaw recommendations that say that it's not admissible even to have an overrepresentation of high-level court judges in this council. That's why we have those quantitative proportions that we put in the draft. In the draft, there is also the financial independence of the judiciary, and those are elements that are here to guarantee the proper fulfillment of their duties. What is new is that this council is ruled by two rules. The transparency rule is something that has been shown over the last 8 years, is that the lack of transparency generates some irregularities, corruption, and it's thanks to this transparency rule that people trust courts more. Transparency is guaranteed through establishing by the Council this code of ethics ethics, through the obligation of giving information on the functioning of the judiciary, of the spokesperson, and so on. Regular reports will be also issued, and there is a possibility of formulating some arguments, and we also propose within the efficient administration those instruments that I already mentioned, and that will be also presented by Professor Walasik in the second part of our meeting. Not to dwell on that, I will answer eagerly your questions during the Q&A session, but let me finish with the following conclusion regarding this matter. Well, we are thinking about choosing this administration model, court administration model. What model to choose? We need to be aware of the fact that comparatist models and the trends in Europe are that those councils have become a soft law, as standards in Europe. In fact, this is what is applied in Europe. So I share the opinion expressed by Professor Castigliotis, who makes a link between the choice of the administrative model with the system in which we function. If we have democratic systems, then a priority is to implement a specific set of rules, which is maximizing the independence of judges, the responsibility of the judiciary, and the capacity of the judiciary to defend democracy.
On the other hand, in authoritarian systems, the models which are preferred are where management is based on maximum subduing the judiciary to the executive power. So what we are proposing is an item for discussion, or the point of the departure for the discussion about the model in which we shape the judiciary in such a way that it will be able to defend democracy. It would be an accountable power that would be the power which would be independent, and first and foremost, it would be the power that would guarantee real right to court each and every citizen that goes to the court. Thank you so much. So thank you very much for presenting a new vision, a new opening for justice. I mean, the solutions that the professor has been discussing are laid down in the book that you have, the rule of law and social bills aimed at restoring rule of law. So the situation now leads to some specific proposals for discussion, but the key question that we have after this presentation, this speech, is the admissibility of this kind of Copernicus revolution, we would say, because according to the law, the competencies of administering the judiciary is to be transferred from the Minister of Justice to the National Judicial Council, KRS. So now I have the first question to you, Professor Moniki Florczak-Wątor. What about the Constitution here? How is it perceived by the Constitution of such a change? So we can, let's say, have no supervision anymore according to the Constitution, to change it to, let's say, administering, and is such an amendment possible based on the Constitution? Good morning, ladies and gentlemen. Let me thank first organizers for organizing the conference, for inviting me to the conference. It's a great honor that I can be here with you today and discuss all these arrangements with you. So, in fact, I was asked to have a look at all these arrangements, not with a view to their detail, because we will have time within the legislative procedure, and consultations with citizens, but I'd like to have a look at it from the viewpoint of the fundamental question, that is whether it is possible to modify, based on the legal act, the current role of the competence of the National Judicial Council, KRS. So looking for the answer to the question, I would like to discuss 4 issues. Let me start with more general ones pertaining to where the freedom of the legislator ends as regards the development of constitutional solutions. The second, some tasks and functions of the bodies which have the status of constitutional bodies, and to what extent the competence of such bodies, which are within or not within such functions, could be developed in the legal act. Because I know that legal acts do it with respect to all bodies whose competencies are in more or less detailed way provided for in the Constitution. So the legal act always develops such competences. So then the question about, let's say, the limits. And the third, I would refer to the model. So what is role in the light of constitutional rules and instruments? And here we see a problem of the lack of competences on the part of the National Judicial Council to issue regulations. So now the limits of the legislative freedom to develop constitutional regulations. So we must start with the fact that the legislature generally has a duty to develop a constitutional regulation, because it has a duty to ensure that this constitutional regulation would work in practice. So constitutionalists, we call it a direct aspect of direct application of the Constitution, which is provided for in Article 8.2, and we take into account the negative aspect that a legislator may not make law which is not unconstitutional, and the legislative also has a duty to develop what's provided for in the Constitution, and is responsible for the fact that the body which is mentioned in the Constitution should function. It would be the body that would have instruments enabling to exercise its competences. That's why it is natural that the legislator develops such a constitutional regulation, but there are some limits, and these limits in the case of constitutional bodies are determined by the nature of the body. Of course, these bodies, as regards specific regulations, are regulated in a different way. But what is most important is the character of the particular body, which determines its, let's say, functions, and the legislation cannot change it. There are various possibilities of amending and of what the legislation can do. So as for KRS, we know the legislation wanted to effectively change the nature of KRS by changing the appointment of members. So that is the change of the character, and that affected independence. And out of a sudden, KRS turned out not to be the bodies provided for in the Constitution, and this is provided for in the jurisprudence of our the Supreme Court and the Court of Human Rights of the European Union. So the legislation cannot also modify the tasks which have a great bearing on the character of the body. It may be more precise of these functions, but it may not modify, and because otherwise the body would not be the one defined in the Constitution. If we look at it, at the constitutional regulation through theoretical things, I mean the regulation on the KRS, so we would see that indeed the system position is decided. So this KRS is included in the part concerning courts and tribunals, although it's not a court or a tribunal, but the legislator wanted to emphasize that it's independent and its competence competences are directly related to the operation of justice. The second thing that we see that the legislator precisely indicated the functions of KRS, functions, tasks. So the KRS is to guard the independence of courts and judges, and this is the key function of the KRS. Of course, it must have appropriate competences to be able to perform the function. In constitutions, we have two competences, and which indeed allow it to be the guard of the independence of courts and judges. It's a competence to make applications to a constitution on determining constitutional of the legal regulation, and the second competence, which is related to the application being submitted to the president to appoint such a person as judge. So these are definitely two competences which are related to the task, but they are undoubtedly not sufficient. Hence, in the current legal act, there are additional competences that are to be used to perform the task. And as regards these added competences, because the draft legal act adds some competences, because of course it repeats some competences, the current one, like giving opinion on draft bills, but it added new ones, as mentioned by Professor Judge just a moment ago, and this is kind of Copernicus revolutionary. These are the administration competences, and we must say that the legislation has a kind of order to formulate competences in an optimum way. So it has an order to add such competences which would enable us to best implement this task. So now going to the draft legal act, because I'm discussing so much theoretical aspects, because I'd like to draw your attention to the provision of Article 2.2, the KRS is to guard the independence of courts and judges and administration of the judiciary. And here the question arises whether the administration of the judiciary is something which is within the functions of being the guardian of the independence of courts and judges, or is it a new element? If we look of other provisions of this draft legal act and its justification, then we can see clearly that this administration, this entrusting KRS with administration is justified by being the guardian of the independence of judges and courts. I'd say that the independence of courts requires that administration of courts should be partially entrusted to the National Judicial Council, because it might seem, if we are to compare this Article 2 literally with Article 186.2, it seems that the second function was added, and in the light of what I have said, that would be controversial. Out of a sudden, it turns out that this character, by expanding the functions, is changed, but I think it's really very well justified in other provisions, and in the justification that administration of judges, Art 2.1, means kind of exposing an element of being the guardian of independence of judges and courts. And the final thing, as regards issues related to the model adopted in this draft legal act, we must say that the Constitution does not decide on the model of administering courts or administering justice. Here the legislator has freedom, and it was already mentioned that in practice there are various models functioning in the West or in other countries. So indeed, here various solutions are accepted in democratic states, but again the legislator has some limits, but these limits are decided by the rules which, from the viewpoint of the functioning of the judiciary, are of key importance. So this is the division of power and the balance of power, and also the rules which are more precise as regards the division, that is the separation and independence principles which characterize this one power, monopolized by the legislator only for the legislative power. If we look at the draft, indeed we see many solutions in it which reinforce and find the justification from the viewpoint of the rules that I've been mentioning. So here, these rules, which are very much emphasized, is the effectiveness and transparency rules, effectiveness and transparency of administration. And these rules are very much justified in constitutional principles, especially a democratic state of rule of law, and this rule has many components. One of them is transparency of the activities of state bodies, which is of key importance. So the effectiveness and transparency principles are justified from the viewpoint of the rules, and they are also justified from the viewpoint of understanding of the right to court and Article 30. So these two principles, especially that of effectiveness, which is to guarantee efficient functioning of justice, are the principles which serve the citizens first and foremost. And first of all, the right to court. And Madam Judge also mentioned the financial independence rule, which is a very important part of the independence rule, because we know that the attack of the judiciary starts with a financial aspect, because this is the easiest way to undermine the possibilities of action of a particular body. So the conclusion is that if we look at such solutions from the viewpoint of constitutional principles, we see that they indeed fit into the principles laid down in our constitution. And the last thing, as regards these model issues, and Madam Judge really mentioned administration of the judiciary, and finally there was another word was mentioned, co-administration, and I think it's a very important thing. The very administration in the draft law is limited with regard to subject matter, because it's limited to courts, and as regards the object such, it's the model of limited autonomy. It's also included in the administration to the Ministry of Justice, self-administration of the judges. But it seems to me that it is justified if we look at the instruments that KRS has. So this is the body that has now possibility to issue the acts of commonly binding laws. It's different as compared to other bodies like the National Radio and TV Broadcasting and Council, or other organs like the ministers, president. So that's why it is obvious that in order to administer, we need such instruments. And what was also emphasized, that is the rule of the cooperation between KRS and the bodies that has a possibility to issue regulations, that is the President and Minister of Justice, is of key importance here, so that the transfer to KRS, the administration of justice, could be effectively exercised. And finally, I'd like to add that the fact that KRS has a possibility to adopt resolutions is not enough, because these are acts of internal law, and it would be even quite dangerous, because each internal law acts, including these resolutions, are addressed to the bodies reporting to the body that issued it. And here we cannot assume that these bodies are somehow subdued to KRS, because that would mean undermining in the independence principle. To conclude, without going into detail, because we will have time for that, so as a person, say, from the outside could say that it's a very promising draft from the constitutional viewpoint. It suggests a completely new look at something that has been functioning in a different dimension, because these competencies were given to political bodies, in particular the Minister of Justice. But it seems that it's also the solution which is very well justified from the viewpoint of various principles that have been mentioned, and the function of the National Judicial Council and its tasks and constitutional position. Thank you so much. So thank you so much. And taking this opportunity, I'd like to say that I'm very happy that Madam Chair of the Senate Justice Committee, Kamila Gasiuk-Pichowicz, has just joined us. Welcome. And Chair of the Senate Legislative Committee, Senator Krzysztof Kwiatkowski. So out of these two speeches, we can see a perspective that we see that we have a new vision for the new model administering the judiciary, so the hope for the change of such administration. And we know that this change is in line with constitutional principles, and it is constitutionally promising. So now the question is, can it work? Does it work somewhere like that? And because if you are to decide to have such great change, or to somehow abandon even the tradition from historical tradition of absolute monarchy administration of justice, so hence the question is about the practice and experience of other countries. And so that's why I'd like to give the floor to Judge Keesa Sterka, who would discuss this issue, because he was the former chair of the European Judicial Councils and the person very much involved in the Dutch Council for the Judiciary will discuss this issue. The floor is yours, please.
So, I'd rather be here than there. That's why I like to see faces. Fellow members of Justitia, ladies and gentlemen, almost 9 years ago, I was invited by the president of the KRS to visit Warsaw, not for joyful festivities at the time, but to share a concern about the future of the independence of the Polish judiciary. It was the start of a wonderful cooperation between friends with a common goal to fight for judicial independence in Poland and Europe. During the last 8 years, our common fight endured many downs, but we also saw the birth of judicial cooperation and solidarity between judges from all over Europe. So I'm happy indeed to be in Warsaw again, and this time for joyful festivities, because we are able to discuss in the Polish Senate not only the restoration of former judicial independence, but even the establishment of judicial self-governance by transferring the administration over the judiciary from the executive power to the judiciary itself. Now, what do I want to do? I could talk about this subject the whole day, but I understand that that's not the time given to me. So what I want to do is to reflect on judicial self-administration based on my experience as Vice President of the Council for the Judiciary. I was the Vice President of the Dutch Council for 7 years. Not to advocate the introduction of the Dutch system per se in Poland, but to give you some inspiration about what it could be and some input in your process of thinking about a new system in your country. I will touch upon several issues. First, the transfer of administration, then the Judicial Council itself, the budget for the judiciary, draft laws affecting the work of the judiciary, and nominations and promotions. And I will conclude with some final remarks. So first, the transfer of administration. In the Netherlands, this transfer of administration of the judiciary was completed in 2002, after a few years of preparation. Mind you, a few years of preparation. There were different reasons for this transfer. Politicians at the time prioritized the modernization of the judiciary and knew that the professionalization of the judicial organization could only be a success in case the judiciary was allowed to govern the courts themselves. The leadership of the judiciary wanted self-administration as a safeguard against political interference. All knew the former examples of favoritism by the Minister of Justice of some courts because he and the president of that court were old college friends, especially concerning budget problems. And the Minister of Justice was always particularly interested in the selection of the president of the District Court of The Hague, the seat of the government, because the power of that president was to order interim measures or not against the government. So, in the transfer of the administration over the judiciary, the interests of politicians and judges matched. There was not a fight about this. I'll go to the Judicial Council. Self-administration started with creating a body that is able to do so. The Council for the Judiciary, consisting of a majority of judges and a minority of non-judges, not politicians or not former politicians, but experts in the fields of finances and administration. All members work full-time, because administrating courts takes a lot of time. Personally, I cannot imagine how a part-time member of a council with administrative powers, selection powers, and disciplinary powers is able to do all this work properly, given that a day has only 24 hours and a week only 7 days. In the 2023 review on the Bosnian Council, which I shared, one of the recommendations was to redirect attention of councillors from selection discipline to administration of the courts, because the administration of courts was neglected, lack of time. And besides, administrating is totally different from judging. The latter is about establishing facts of the past in the light of the law and judging according to the law. The former is shaping the future of judging without a clear guidance in the law. Because of this different character, administrating does not come easy for judges that we experienced in the Netherlands. So extensive training and selection are necessary. I personally know a lot of brilliant judges who are terrible administrators. And I'm not telling you a secret. They know themselves very well. So special selection criteria for members of a governing body are absolutely necessary. I'll go to the budget. Without a budget for the whole of the judicial organization, so council, courts, judicial school, IT for the judiciary, housing for the judiciary, the council is not able to administer independently from the executive. So the council negotiates with the Minister of Justice about this budget. Presently, 1.2 billion euros for the whole of the judiciary. The Council may appeal to Parliament directly in case the negotiations are not successful. These negotiations are every 3 years to protect the judiciary against the delusion of the political day. Another safeguard against political influence is to create as much objective criteria as possible as the fundament for the budget. The Minister of Justice is not allowed to earmark the budget to prevent another possible political influence. So earmarking meaning that they say you get 20 million, but you have to spend it on this or that. No, we just get a bag of a lot of money and we are allowed to decide how to spend that. The Council splits the national budget in budgets for national services, judicial school, IT, shared services, the Council, and the courts on the basis of more or less objective criteria elaborated in rules. The Council is accountable for the spending of the budget to the Minister of Justice and to the Parliament. The Council selects the presidents of courts, which are integrally responsible for every aspect of the court. Judges, staff, budget, quality of the court, housing, IT, for instance, and also for the productivity of the court. This is important because it prevents productivity of judges entering into the disciplinary system. That is not the case. So if the production of a judge is too low, it doesn't go into the disciplinary system, but it goes into the management system. Meaning, I've been in the board of the Court of Appeal and in the Supreme Court, meaning that you first go and talk to someone and ask, why is your productivity low? Are you in a divorce? You have a sick child? Are you not well yourself? Etc. And then, or do you need additional training? Whatever. So it's not in the disciplinary system. Okay. It also, the Council also attributes courts a yearly budget based on an objective criteria as much as possible. The president of a court is fully accountable to the Council, and this is done in 3-month meetings with one member of the Council for a specific court, and that member reports to the full Council. So in my days of the Council, all appeal courts were in my jurisdiction, so to speak. Now I go to the subject of the draft laws affecting the work of the judiciary. The duty of the Council to administer the judiciary implies a say in draft laws concerning the work of the judiciary in the form of advice to Parliament, solicited or unsolicited. It requires good relations to Parliament, for instance, by giving evidence in round tables. I, for instance, was responsible for advice on draft criminal law. The advice given was not political, but always based on law and legal practice. We were rather successful in preventing laws judges were very much against, just by explaining what the practice in the courts was and how the draft would negatively affect this practice, or explaining what European law requires. As an example, I mentioned the introduction of minimum sentences, which we prevented, or sentencing guidelines by the executive, which we prevented as well. There are some sentencing guidelines, but they're made by the judges, not by the executive. But sometimes it didn't always work, I'm sorry to say, and we just had to swallow the new law. In this dialogue with the Parliament, there are some rules. One of the rules is that we never discuss an individual outcome of a case. For Parliament, this is very difficult to abide to this rule. As I said, I was responsible for criminal law, and there were always very many questions on a particular outcome of cases, but we were always very friendly, or I was always very friendly, and very strict, no answer. The same goes for individual judges. We did not discuss individual judges. We refused to do so. And these are some of the preconditions in which you can have a dialogue with the Parliament. Now, the nominations and promotions. Well, the Council only selects the presidents of the courts. For all other selections, except the members of the Supreme Court, the Council has a responsibility that the system of selection works well. So, for instance, the Council appoints the National Committee that selects the judges, the initial selection of judges, and sets the criteria for selection. So it doesn't select itself. It has under the Council, there is another committee that selects the initial selection. Every judge has to pass this initial selection. And then a judge has to apply to a court. So it's a mixed system. There's a national part of the system, and you have to apply to a court. And if no court wants you, then you do not become a judge. And the same goes for promotions. The Council has no responsibility for promotions except to facilitate it. How do promotions come about in the district courts and in the appeal courts? It's the courts themselves who decide who gets a promotion or not. And if you are not pleased with the rejection of a promotion in court A, you can try in court B. And sometimes it works. But so there is not a national system for promotions. So a facilitating role for the Council there. I come to my final remarks. The transfer of the administration of the judiciary in the Netherlands involved the transfer of the total budget of the Ministry of Justice to the Council. The introduction of integral responsibility of the Council to the Minister of Justice and the President of Courts to the Council, the duty to advise Parliament on draft law, and much more, which I will not touch upon this morning. This transfer is a process that has implications in many fields, such as concentrating powers in one council or not, selection criteria of council members, selection criteria of presidents, composition of the council, etc., etc. Judicial self-administration asks a lot of the judiciary and its members. Do not make any mistakes about that. Governing self-administration is a tough job and not always a nice job. However, I feel self-administration is most certainly to be preferred over administration of the judiciary by the executive. And this opinion is based on the important successes of the transfer in the Netherlands. And I just mentioned a few of these successes. The first is that the political influence in the courts through management or budget is nil, no influence whatsoever. And as I said, if in Parliament a council is asked about an appointment in a court, we just say, we don't talk about individual judges, we do not talk about individual judgments. The only thing they can say about appointments is something like, and I've had these discussions, there are too few ladies in the judiciary, or there are too few people with, in our country with a Turkish or with a Moroccan background. That is in abstract terms, this can be discussed, but not in concrete terms. So, no political influence. And the same goes for selection and promotion of judges. Sometimes Minister of Justice try anyway. We had a appointment of a judge, of a president of a court, and there was a new Minister of Justice. He was just 1 week in office, and he said, "I don't know this man. I'm not going to appoint him." And we just kept calm, and we said, well, you know, at some point, questions will be raised by the press about why this person will not be appointed. And of course, we are judges. We have to tell the truth to the press. And then the Director General of the Ministry of Justice came to me and said, "Give me 1 week. He's just 1 week in office. He doesn't understand it yet." And that was the only example in 7 years I know, and this person we selected was appointed anyway. Another success, that the necessary modernization of the judicial organization is led by judges, not by civil servants of the Ministry of Justice and not by politicians. And I think this is important because that has an effect that the modernization is more successful than it is ordered from above, so to speak. It comes from the bottom. And the last success I would mention is that the judiciary is more influential in Parliament because Parliament sees the judiciary more as the third power in the state and not just as Court A, Court B, Judge A, or Judge B. And we have more influence there. In other words, the judiciary is not only better able to protect itself, which is important enough, but also better able to shape its own future. And that is what I truly wish for my Polish friends and colleagues. May Poland once again become a leader in historical events in Europe, this time, I trust, in the field of the transfer of the administration of the judiciary. Thank you for your attention.
Podczas tego dzisiejszego panelu
During our today's panel, we saw this perspective which is contained in social draft laws aiming at rebuilding our judiciary. There is this practical perspective and theoretical perspective, so there is some time left for discussion. I would like to invite you to this discussion. I think that it could be organized in the following way. First, we collect the questions, and then we will get answers from our speakers. Considering the fact that the conference is broadcasted, please introduce yourself first before asking a question. So please, the floor is yours. Are there any comments, reflections, or questions? Mr. Prusinowski, President of the Court.
Szanowni Państwo,
Ladies and gentlemen, I have a specific question. Maybe it's not typical. I've read the draft, and I must say it's a good draft. But if something is good, it doesn't mean that it couldn't be better. So let me take this opportunity and because we have Professor Roszczynialska, who also contributed to the creation of this draft, and that we have also among us Mrs. Florczak-Wątor. I would like to ask questions. We are talking about the National Council of the Judiciary, not of the judges. So modern judiciary is not only judges. There are also our other clerks, court clerks. When looking at point 8 of the draft, we could see some points and some gaps in this project, because in this draft, because there's no reference to those groups which should be represented, and they are not fully represented now. So my question is the following: do you foresee, as legislators, the strengthening of this group regarding the functioning of the Council of the Judiciary, because those groups account for 80% of the whole judiciary. They are at the very core of this institution. And I would like to ask Professor Florczak-Wątor whether in the constitutional aspect, extending the powers of the Council by elements which are not specified directly in the Constitution, is it really admissible to do it? Of course, extending competences concerning those people should consist on a specific control on selecting people, ensuring a proper budget. The Council could have an impact on that, so that politicians don't have even an indirect impact on that. This is my question. Thank you very much.
Thank you very much. I see that President Bogdan Zdzienicki would like to ask a question. So please give President the mic. Thank you so much, because well, it was difficult for me to get here into the conference room, and well, it was a great effort for me. So I got here finally, and I'm an 80-year-old man. So that's why I want to ask a question. And I'm also encouraged to do so by my wife, Małgorzata Gersdorf. And I must say that we must go also against the Constitutional Tribunal, who said, as Professor Granat, as a rapporteur, who said that the independence of courts means that it's independence in judgment, not independence in organizational matters. Of course, it is inadmissible, but on that basis, acceptance of some solution was based, because it is as if same was independence in adopting all laws, and other issues like financial issues should be really dealt with by the court. And let me remind you that the model that was adopted later on was extended, was adopted in the between war period. It was not authoritarian, maybe government. Nevertheless, the country was not so democratic at the time. So these ideas adopted then, that judges must be part of the power of the state, now are inadmissible. Now, what was said, that considering all these things related to administration of the judiciary requires that the law on the Council of Ministers and fields of government administration should be taken into account, because there this court is part of state administration, which is against the independence of the judiciary. Whether any other models, different models. So let me remind me, as the former judge of the Supreme Administration Court, that judiciary administration is administered differently, because the president plays such a function as for ordinary courts is played by the president. So we have some experience here in Poland that also someone connected with a judiciary power could play such a function as the professional judge administering such court with appropriate instruments, and it's going quite well as regards administration here. I mean, not only the building of administrative courts all across Poland. Here we have been successful, and equipment as well. The situation is worse as regards the instances of these courts, because the model that was adopted it should not have been adopted as regards especially in judicial review. So in a situation where we don't appreciate the judicial power so much, it is related to the history, not only from the Second Republic of Poland. So there are many publications on the 100th anniversary of the Supreme Court, which was established earlier than Poland regained its independence. So many mistakes were made when the judicial power was treated during the Polish People's Republic, and also in the period after 1988, when it was not fully understood what a democratic state of law means and what the tripartite division of power really is and how it should look. It was now reminded to us by Judge Sterka, really an excellent judge, and the Netherlands is a country that we should really have a look at because of its developed democracy and the practical approach. And this is also important as regards relationships with other powers. I don't know if it's taken into account. But first of all, judges, the judicial power has to have a great impact on the legislative power in the form of compulsory consultation, because we are, let's say, slaves of the Constitution and laws, but the law should be, of course, in line with the Constitution, and this should be all regulated. And the example of the Netherlands shows that, and it is very good that there are some relations with the executive power. Well, it might be discussed, as already mentioned, that justice and its efficiency does not depend on judges and their fast work, but also on how other professions cooperate with it, a kind of auxiliary from notary public, where you can examine the compliance of the Notary Act with the district court. Of course, there are also legal counsellors and barristers. So the solution of all these issues requires that relations are defined with these professions, which decide about the justice dimension. I don't know if there are some solutions here, or only with regard to legislative power, and therefore the question is how the representation should look. Another, the last now thing, the ideas such as elimination of the post-communist system, for example. Well, I come from the family with great traditions. My family members took part in uprisings in the 19th century, but very often using that slogan, the Polish state was being eliminated or dissolved. And we see here many judges from KRS, and they know that many things were eliminated, those that were the result of the tradition. So, well, it happened where peace was in power, but not only then. And let's say that our slogan is citizen, law, and state, which has its rules and it has its tradition. And finally, not to dwell too long, the judge. What kind of judge should it be? and how he should be selected, it's not very well defined. And according to Dworkin, whom we don't read so much, it should be Judge Hercules, because he must face challenges as regards not only as regards education of Polish and EU law, but also he must know a very broad background, and he is to make judgments according to law and his conscience. So indeed, there are very broad philosophical and economic horizons here, and therefore teaching lawyers during their studies and then training of judges should look differently. And finally, there should be continuity of the statehood. Let's look at all good experiences. I was a trainee in 1969, and I'd like to say, because, I'm not a person who's such a conformist, but yeah, it looked better than now. And although we are, of course, using different arguments now. And let me tell you about one more experience that I wanted to computerize the court system, and that was done thanks to the effort of judges. And well, that was really difficult because of all these kind of budgetary restrictions. But the computerization of the judiciary must be restored, and it must be developed all the time. At the moment, land register, which were computerized, and now we have had some negligence in that, and the process takes a long time, and the computerization of court registers was based on Norwegian models, which is the best, because we used to have Austrian and German models. And if I may, I would like to say that we should follow some other models as regards administration. That is the Dutch model, that we combine faith in ideals, pragmatism, and experience of that great democracy, which does not need the constitutional tribunal. At least it did not need until so far, because the legislative process is so good. They don't need any extraordinary controller to do review of something. Thank you so much. I hope we will have now more questions, but please be brief so that participants in the panel could respond. My name is Wojciech Piątek. I'm professor of law and I represent the Supreme Administrative Court. As has just been said, here in Poland, the administration system is different. For administrative courts, the system administration is different, as Judge Sterka mentioned, and the president of the administrative court is responsible for administering administrative courts. Hence, I have one question to our guest from the Netherlands. Professor you mentioned the issue of doing the reasoning for court judgments, and that various models are being prepared, some forms which are to help judges to give very good reasoned opinion, coherent ones, transparent, etc. And we are now dealing with that topic, what to do so that our judgments and reasoning should be coherent and should be first and foremost comprehensible to citizens. And Professor, could you say a little bit more about it? Could you share with you your observations in that respect? Thank you. So I think we may now close the list of questions now. So the question concerning the reasoning or justification could be answered during the break, during your informal talks, so that we could give more answers of pertaining to administering of the judiciary, so that we would still deal with this topic So first, Professor Roszczynialska. So let me answer the questions in the order asked. So the first question is based on the name, the National Judiciary Council, but there are different names. Like in Spain, there is a different one, which means that it's the body of the court's power, of the judicial power, and that's the essence of our National Judicial Council. It identifies with the court's power. The name was adopted in the Constitution, and that is we should ask the authors of the Constitution why they selected such name. But the assumption is such that it really pertains to judges. It's the same situation like in France and Italy, I guess in the Netherlands as well. We will ask here, Professor, whether it pertains to the judicial power, the judicial. As for other professions, clerks, we did not omit them. Have a look at the Article 28 in the draft law. So, well, they are described there and provided for as in line with the justice system, because we have the status of such employees as regards court registrars. We will discuss it later on how it all should be regulated. But as regards the detailed solutions, we don't omit them, and these professions are included in this law, and we are open to any suggestions how to improve the provisions pertaining to them. And as for one more question concerning consultation, it is not so that we forgot about it in the draft law. So it is provided for. I mean, so there is consultation and giving position. It's Article 7.7 and 8. So the KRS gives position on courts and judges as submitted for discussion by the president, other bodies and other organs, and suggested by international organization. And I did giving opinion on various acts on judges, including remuneration for judges, and submitting implications in this respect. So here we also envisage this competence for KRS, but the question is how these provisions would be interpreted and how the cooperation would look. And I would say honestly that at the stage of discussing the legislative shape of the planned solutions, we discussed whether cooperation between the powers should be regulated in line with European standards. And here we encountered a kind of very conservative constitutional approach, that is whether it is a statutory issue and subject to regulation. I'm in favor of such arrangements, but there are also opponents, and definitely the issue of regulating the issue of cooperation between bodies of the public power with the judicial power. This is the issue that we should go back to in our discussion, and that's my opinion. So now, Professor Florczak-Wątor, please. Yeah, thank you so much. In fact, there was one question addressed to me, but it's very important. So, answering the question, let me give you the example of one of the judgment of the court that you still, I guess, remember. The question is generally about whether it could be possible to extend this regulation and solutions in the Act by additional one, in addition to the one mentioned, that is including these employees, that is assistants, court registrars, etc. So my answer is yes, because it's a part of the component of guarding the independence of courts, because they are employees of courts. So that's obvious that it is related to how this part of courts is organized and how it affects independence. Let me remind you, Judgment K47/15 is judgment on the so-called STAR law of December 2015, which concerned the amendment of the law on a tribunal, which had a paralyzing effect. So one of the bodies that challenged it was KRS, and we must say that this tribunal, and I was there, so I might say that I'm saying that there was a discussion whether KRS has such competence, whether this component of being guardian of courts, of independence of courts, but the tribunal is not a court here. The constitutional tribunal is not a court. So if you just have a look at the reasoning or justification of the judgment, the competence of this competence of KRS was not challenged. So that's an additional argument from that judgment, that the notion of court was broadly understood, as the tribunal considered that KRS could challenge that regulation. I do not fully agree with it, but well, answering directly that question, I would say that we would not face such dilemmas and we could consider such employees and include them here. Thank you so much. Now, Professor.
The Dutch Council, in many of its powers, it has a facilitating role. So one of the facilitating roles is the enhancement of quality of the courts, quality of the work of the judges. And the method to use is not to impose a kind of a quality on the courts, but to organize it from the bottom up, and we facilitate this process. So to make it more concrete, we had the same problem which you mentioned, that too much judgments were only understandable for people who had a legal training. And sometimes that is not to be avoided, but we thought in the council at the time that it should be more transparent and more in plain language. And how did we do that? So, for instance, if we think that in my field, and the criminal laws are more easy to explain, what we then did is we organized a group of judges from every court one, a distinguished criminal judge from every court, and we made that a permanent group with which the council member would, well, have meetings and discuss this kind of things. Then we asked them, you must have in your courts, you must have good examples of there always are, you know, it's not that bad, there always are. And what we then do is we say, okay, what do we see? So what could be a good model, or could be, well, a good way of phrasing, etc., etc. And then we do two things. We make a kind of handbook, that these are kind of phrases which are legally okay, but better to understand and we make that book, it's under the supervision of the council, and we give it to the courts. And we don't say you have to do this, we just say this is a suggestion which you can use if you want to. And you always do. You don't have to top down it. Another thing is that we organize trainings about this. And we make a kind of competition who writes the best judgment, which is understandable for, etc. So this is the way we organize this. We don't impose it. we try to seduce judges. Sometimes we push a little bit, and that's the way we do it, and it usually works. I hope this is an answer to your question.
Thank you very much.
Okay.
Bardzo dziękuję. To jest chyba nie tylko odpowiedź.
Thank you so much. It's not only the answer to the question, but also the announcement of another panel where these issues related to the instruments for efficient management of courts should be introduced, and how, whether in laws or maybe they should be soft. So let me invite the next panel participants that will be moderated by Madam Judge Kmieć.
Proszę Państwa, zaczynamy już drugi panel bez zbędnej zwłoki. Zmęczymy się po następnym panelu i wtedy dopiero będziemy mogli...
So let's start. After the next panel, there is a coffee break according to our agenda. So we'll have enough time to have a break later. Judge Anna Wypych-Kmieć will be the facilitator of this part of our conference. Let's start, please. Ladies and gentlemen, I would like to invite you to our second part, which will be dealing with the system of weighing cases as a new effective tool, administrative tool for the judiciary. And I have the pleasure to present our guest, Dr. Marcin Walasik, from Adam Mickiewicz University in Poznań, a judge in Poznań, and also a civil matters visitator in the district court in Poznań, member of Iustitia Association, and a member of experts group elaborating Common Courts law, and member of the Codification Committee for Judiciary. The second guest, Michał Jabłoński, a barrister. Mr. Jabłoński is at the Faculty of Law of the Warsaw University. He is an expert in litigation and public cases and strategic litigation. Those are his fields of work, and also the independence of the judiciary is one of his fields of work. And my third guest is Judge Mariusz Bartnikas, the president of Regional Court in Kaunas, and also a member of president of the council, Judicial Council in Lithuania. What we will be discussing during this panel, Professor Marcin Walasik will present you modern tools of administering the judiciary, because a modern judiciary is an efficiently functioning system that responds well to the present needs. It's a modern system which will administer HR resources in an optimal way. And modern judiciary is also a system where each and every one of us as citizen has equal access to court, and there are equal deadlines for filing and reviewing the cases. A modern system is a system that eliminates discrimination of citizens regardless of the jurisdiction concerned, considering the consequences of the lack of efficient management of judicial human resources. Thank you, Judge, for giving me the floor. As it was said, the subject of my presentation is the weighing system and the extent which is provided for by our experts from the Iustitia Association. This is a technical issue, in fact. Nevertheless, it has had a key role in ensuring the efficiency of the judiciary, especially the implementation of the right to a court proceeding, the warranty for a citizen to have a court case reviewed in a decent deadline, within a decent deadline. That's why administering courses requires weighing cases, administering cases which are filed to a court. If we had to look at the current state of play and regarding the functioning of common courts of law, well, the analysis of the burden has been attributed to the Ministry of Justice. The ministry is responsible for collecting data about it. It is different as regards administrative courts and the Supreme Court because they are somehow administratively apart. So data collected by the Ministry of Justice is limited only to the number of cases which are filed to common courts of law and cases which are resolved finally by those courses. And this statistics does not specify the complexity of those cases and the duration of the proceedings. But everyone who could see what is the specificity of cases which are filed is aware of the fact that cases differ from each other. When it comes to cases resolved by courts, they differ from each other, especially when it comes to the workload dedicated to a given case, but it also is reflected by the time which should be involved. So when preparing this presentation, I wanted to give some examples. So I decided to give an example of a bankruptcy procedure, proceedings. For example, now we are having a bankruptcy proceeding towards one of our banks where assets account for billions of Polish zlotys, and we have dozens of thousands of creditors and debtors. So in ministerial statistics, this will be case number 1 in terms of how it will be resolved. It will be resolved in some time, and the same importance is given to a case bankruptcy, individual bankruptcy of an individual client, client of a bank who got some loan from a bank. So his assets, for example, is a flat. So those are cases which are incomparable in terms of workload and in terms of how time-consuming they are. However, statistically speaking, they have the same value, which means that using this tool does not allow us to have the proper image of the burden that is imposed on our courts when they are dealing with those cases. So as a consequence, because of this lack of data, there is no reasonable policy in terms of administrating courts, organizing the work of the judges and all the clerks, assistants, and all registrars, court registrars. So I prepared for the needs of our presentation one example showing how far from reality is to use those statistics. Let's look at data from 2022, and it results from this data that about 14,000 cases were resolved in 2022, which results from this data is that about 38% of those cases, 5.5 million, were resolved by 9,000 judges, which is 591 cases per judge, in fact, according to those statistics. As a comparison, in 2022, about a group of about 2,700 registrars reviewed about 9,100 cases, which is an average of 3,000 cases per court registrar. So when using those statistics, we could draw a conclusion that court registrars are 5 times more efficient than judges because they have resolved more than 3,000 cases per person, whereas regarding judges, we had only 600 cases per judge. But you may agree that no conclusions could be drawn from that because statistics do not take into account the differences between cases which were resolved by judges and by registrars. The biggest paradox that we could draw from that is that if we, for example, had 2 times more registrars, we didn't need any judges anymore because registrars could easily deal with all the other cases that have been dealt with by judges. So avoiding this kind of paradoxes. This is why we introduced the system of weighing cases. It's a system that is here to give us the opportunity to benchmark, to compare how time-consuming some cases are and what is the workload regarding those cases. It is based on the fact that there are some theoretical possibilities of calculating the time needed for a given case. And the second element of this system is creating categories of cases. There are groups of cases, for example, which are equally time-consuming. And the third element of this system is about the scale given to some cases, which means the importance of cases in order to compare them, compare their importance, and to make a difference as regards the workload needed for those cases to be resolved. But it must be stressed that in our system, this solution has not been applied yet. When we look at some examples from abroad, we can see that working on the methodology of weighing cases started in the 70s in the USA, in the 70s of the 20th century. As regards Europe, in the majority of those countries, there are such systems of weighing cases. They are present in different forms, but they fulfill the specific needs according to country specifics. And Austria, it's the country where this system has been till the beginning of the 90s, and also, there are other countries which have such a system: Bulgaria, Czechia, Croatia, Denmark, Estonia, Finland, the Netherlands, Romania, Ukraine, Turkey, or Italy. This is data for 2020. And, of course, Lithuania, our neighbor, has such a system, and we will know all the details about this system later on, which is really important important is also in the European Court of Human Rights and European Court of Justice. There are such systems which are based on parameters in order to qualify and specify cases. But in countries where such systems are not known and there is no weighing cases, among those countries there is, for example, Belgium, a specific case because in this country this system was there for some time, but as for 2020 we also have among those countries Slovakia and Armenia, and also Poland is part of this group. In a survey that we performed among Council of Europe countries, the question which is addressed to Poland, and what was the answer, what kind of weighing systems are there? The answer was that there was a randomizing system which allows only to distribute cases, but without analyzing their complexity and their importance. So this indicates how much there is to be done. In our case, we need to catch up because we haven't done it for more than a dozen of years. So within our group of experts, there has been some works on the concept itself, and we wanted to suggest some solutions. They are contained both in the draft law on the judiciary, but also on the draft law on common courts of law. So as there has been some modifications in our drafts, according to the projects, the competence here should rely on the KRS that will be here to, so to say, administer courts, and we've assumed that this competence should be attributed by way of a resolution on the judiciary, considering all the controversies concerning this part of the competence of the KRS. According to this, the KRS will exercise this power towards all common courts of law. It will be an instrument of administering common courts of law, but it will not apply to military and administrative courts because, as I said, they are organizationally apart from this system. So how to characterize this system according to draft laws? Yes, the presentation is on screen. So this is what it looks like. Cases should be divided into categories. Yes, this is the most important question about this presentation. So there should be a comparison between cases in terms of how time-consuming they are. Of course, I don't know, this is not specified strictly what kind of approach to adopt. There could be an empirical approach specifying what was the real time dedicated to a specific case by a judge. There could be also an experts-based model where this average time will be also calculated, but there are also systems which bring together both approaches, and the project requires this division into category to take into account the nature of cases and the complexity of those cases. Let me get back to the first example, the bankruptcy of a bank having big assets worth billions of zlotys and thousands of creditors. At the very beginning, this case could be qualified differently than a simple bankruptcy. So it's required by the law that the KRS introduces criteria justifying the qualification of a case in a given category, so that this weighing system is first of all transparent and that it could be controlled, especially by the judge interested in this case. And according to this draft, the KRS is here to establish the scale of those cases and their categories, so that it's possible to benchmark, to compare cases resolved or filed to a court. As regards the methodology, weighing methodology, this draft is based on some outdated assumption. It admits that when the case is filed, the president has to weigh it and take into account judge's opinion on that, and then a case is given to a specific judge who knows how much it will last to process this case. But we are aware of the fact that Europe has been using more modern solutions in countries where such a system is functioning and which allows it in a digital way. This is done automatically based on algorithms. If the Polish legislator wanted to digitalize such court proceedings, then it should be taken into account as part of IT infrastructure that is processing all the cases. Of course, there's always this human factor which is needed, which will be here to control the results suggested by automated systems. So how those aims of weighing cases are seen by the system. So according to assumption, weighing should refer both to filed cases which are filed to the court to ensure this fair division of cases which are filed to different courts and judges. But also there is another weighing after case resolution, because it's based on our experience is that a case which may seem simple, in the end it's not like that, it's quite complicated. And the other way round, for example, there may be a complicated case, but after a withdrawal of the claim, this case becomes simpler, and it should be detected somehow by the system. This difference should be detected. In general, the introduction of this system should make this methodology more equitable and fair. So what's important, after introducing this system, after testing, we think we'll be able for the first time to see what are the needs in terms of personnel in our judiciary. Now we are only based on a statistical model. What counts is how many cases were filed to a court, but without considering the importance and complexity. And now we are not able to specify whether we have enough personnel in the judiciary in order to ensure proper proceedings. So as a result, this kind of system could give the carers a specific tool, thanks to which it will be possible to make proper decisions in terms of allocating personnel. Of course, non-transferability of judges, this will be applied as a rule, of course, but some new jobs could be created, for example, and new positions. But what is the main rule to be applied is the access to court for citizens and the right to quick proceedings, to good, fair deadline. Only in this case we can talk about real tools which will allow us to have a good diagnosis of the situation in the judiciary, because the data that we use now is only general, and it has a statistical error which does not take into account all the differences to be considered. So my last remark, if I may, concern further effects of the implementation of this system. This parameter has to be taken into account in the general map of common courts of law. It will be general information widely available and will consider burdens of specific courts and judges. And this solution has two aims. First of all, it is here to ensure social control over administering courts. Based on this information, it will be able to say whether the decision of allocating a given judge to a given court is based on those statistics, is justified by those statistics because of the importance of the case. So a judge is relocated because of the importance of the case. And secondly, it will give our citizens a tool thanks to which they will get proper knowledge about the burden on some courts, and what's more, they will be able to check what kind of workload a given judge has in a given court. What is a curiosity is that the Supreme Court offers already this kind of solution. If we get to their website and we get to the tab Sprawa, we introduce the case number, we get the information both about the judge, but also there is information on how many cases of this kind are being dealt with by this court, by this department, and it will give us some estimate about how much time it will take. So last but not least, well, the introduction of the weighing case system should be an introduction to a debate on establishing the time limit of working time for judges. Now it's not, in fact, limited anyhow, because the number of tasks is not limited. What decides about the workload is how many cases are allocated to a judge's office. So, in fact, it's limitless. Such a judge must deal with all cases that come into his office, that are filed. So, in the introduction of such a limit would mean that once there is we exceed this limit, such a judge may have some free time, and if he prefers or she prefers, he can also, for example, take part in some trainings and not only keep dealing with cases. Now it's not possible, unfortunately, and the burden is so huge that it has a negative impact on judges' health and their family situation. So we don't have any instruments that could protect the well-being of our judges. As an effect, this system should allow for establishing a guarantee of working time limits imposed on judges.
So, ladies and gentlemen, we just heard that modern effective justice is the system which is weighted and measured. So on the one hand, such actions are against the overload of work of judges, the great differences in Poland as regards the workload of cases of judges, in particular courts, and there are really drastic differences from 100 cases of a similar category at a similar court level to over 1,000 cases per judge. On the other hand, the system of weighting cases is able to counteract the differences in the time of proceedings depending on the court where the case is being conducted. So the court that has less workload would do it faster, but the court where there is a great workload and the human resources were not diagnosed properly for the court, we would wait for a very long time for the resolution of our case. So now I'd like to ask another guest, that is Professor Jabłoński, how from the viewpoint of stakeholders this looks the situation of weighing cases, how the modern administration of the justice system is perceived. So the system which can be verified, measured, and which could also be monitored by the public. Professor, now the floor is yours. Thank you so much for giving me the floor. When I first learned that in social draft laws there must be some systemic solutions, so then I finally thought, okay, welcome to my world, that's good. There's an old joke which is mainly understandable for, say, barristers, legal counsels working in Poland in large law offices, were about the fact that the partner from a large New York or London law office is in front of St. Peter and he's complaining, why now I'm still young? And then St. Peter says that according to the billing, it's completely different. You are at a completely different stage of life. So, well, why am I saying that? Because if you want to seriously implemented the system of weighting cases based on real data, first it would be a painful process. It would be a very serious cultural change also with regard to collecting and analyzing data. That's the point of departure. So first, to collect data properly. So it's not so that an expert would estimate it without any earlier real sample of really measured time. So to be straightforward, you will have to learn from us how to measure time, because we in big law offices that are very modern ones, we do it. And it's not a simple and pleasant process. When a junior associate comes to the law office, he doesn't understand why it should be done, and he thinks it's a necessary evil. I myself, when I was once a young lawyer, I did not understand at all why it is like that. Why do they bother me every week that I have to have registered everything, because otherwise they may block me the computer. So, well, to understand why it is like that, why we should bother about it. So most people don't understand why we should have it, and you will have to understand why we should have it. So once in the office that I used to work for, a guy from London came and he explained to us why it was introduced. And then I understood, because, well, sometimes even experienced lawyers said, why should I measure time? I measure in such a way. I mean, I settle accounts with clients in an appropriate way, so it's not necessary for that. But it's not to be used for that purpose. It's used to understand which resources we use at work and at which cost. These are the most important things. The other things are of secondary importance. You may decide on anything. You, as courts and judges, you don't sell, let's say, services. If we were to compare it to, let's say, law offices, but you can and you should measure the resources which are used for the actions taken. It is the point of departure for any further activities, reforms, or rationalization. Without the data, it won't happen. So to implement it, even on a sample basis, because I know that it would not be possible that we would force all judges or all judiciary employees to start measure time. But if you indeed would like to weigh these cases, that even before introducing the relevant regulations, resolutions, or laws, you will have in some pilot projects based on the sample of judges or the judiciary system employees you have to do it. And we, as the lawyers who know how to do it, we may help you with it, but we would not replace you, but we can tell you how to do it. And there are tools for that. It's not a problem. It's not so that the tools require a special treatment. It's relatively simple. You just have to change your culture and approach to it. So you can do it. If you know how much time given case takes, then you can divide it into categories or you can classify it according to the content, the type of cases, etc. So, well, here, in the previous statement, it was said that it would make things easier for the KRS. I mean, the introduction of court cases, waiting of court cases will make it easier for KRS to work, and they will need less time. So this is important in the macro scale. I mean, management of all resources in the judiciary, regardless whether we mean here the whole judiciary system or some courts. It is important from the viewpoint of a single judge, that is the administration of his section and his or her efficiency in judgments, in giving judgments, in administering his or her cases. That's why this knowledge is needed. So very often when I take part in various court proceedings as a representative of some clients and cases, you know, the efficiency generally is at a low level. That's the diagnosis that I can make based on my personal experience, and I guess you also have such experience. And I often see the blame that put on judges. Well, people say, okay, they have tools, they have preparatory proceedings, the plan of the trial, and why don't you use it? But I know why you don't use it, because you don't have time for that. Because you must think first on administration of your own section of the cases that you are conducting. So I have cases, I have to manage them. If I had too many, I wouldn't be able to cope with that, and I would get into this spiral of being late. So first you have to give the judges the possibility of using this instrument, and here the point of departure is also this system. That is first collection of data, time measurement. And you will see that it will turn out that the similar cases will have different results as regards time, because it would not be, because there are time differences between cases, and there are differences between judges as well. One is more, the other is less efficient. It's not a problem as such. Maybe someone is more accurate, that's why he works slower. Is it a problem? No, but we must know it. we must later analyze it and draw conclusions. Why do we need it? I mean, this is a very good question, but the answer we had partly in the previous presentation. But in addition to these obvious things, that is the management of the resources, the other question is, what do we want to motivate someone throughout resulting from the process that's measured, etc. So to punish for deficiency of proceedings or not? That I don't know. That's a question to be answered, but I'm not convinced that the one who works more slowly should be punished for that. No. Maybe he's more accurate. Maybe he gives better judgments in accordance with the law, which are better perceived by the party. So you must think about it. In addition, there is one more important thing. If someone is efficient, gives judgments much faster, let's say, these cases are better administered, then is it profitable for him or not? Because when he finishes the case, he will be given another one. So, well, it's better than if we have the weight of the case, which in the system of weighing cases is there, and we know that such case will take some specific time, and we know that there is the judge who will do it faster, but is it really a good solution for him to do it faster? Maybe he will do it within the time limit that he has. Everyone would be satisfied, but will the system of justice be satisfied? Will the citizens be satisfied? Maybe not, because it could be done better. Maybe someone should be really rewarded for being more efficient. And as I mentioned, you must have time for your own administration of your cases, because very often people say that judges should not have no other commitments than giving judgments. Of course, they shouldn't do any technical things like putting stamps on envelopes, but that's true, but nobody will replace you in judging. There will not be any official who will tell you what to do so that you are efficient, because then it would be interference. It's a technical thing, but it would be managing your section, but you must do it yourselves. You must learn how to do it. This is the effort you must make. Some of you already know it and you do it, and definitely it will be a painful process. And finally, let me put a kind of open question or express my doubt. They say that there is this kind of academy, Fiat Justitia, so justice must be done regardless of costs. But the question is whether it should really be like that. If we measure the resources that we use to hear some cases and we compare it with the social impact of the case, how it is translated into reality, then I don't know. But in my opinion, it's an important question whether on the basis of this data, of the analysis that we will carry out thanks to the system, we may come to the conclusion that some cases should not be referred to courts. They should not be resolved there. Maybe some other bodies should be entrusted with such cases, because it may turn out that indeed it is not from the viewpoint of using the resources to the effort made worthwhile to do that. Thank you.
Usłyszeliśmy przed momentem.
So a moment ago we heard that the more caseload of the judge, the more difficult time management of his is. But this is possible, and it could be guaranteed by the modern system of waiting cases. So now I'd like to ask another guest of ours to tell us how Lithuanian judges manage their time and how the system of weighing cases helps them, because in Lithuania the system has been recently introduced. So, Mr. Judge, please share with us your experiences. The floor is yours.
Hello, Maya. Oh, yes. These are the slides. Yeah, is it possible to turn on the slideshow? No? Yes, in the corner up there. Yeah, thank you. Well, since the conference is dedicated to interesting and relevant issues, I'd like to thank the organizers for the invitation and the opportunity not only to share my own insights, but also to hear other speakers, their ideas that could be useful back home, and it's a privilege for me. And before I begin, a few words about myself. My name is Marius Bartninkas. I'm a Lithuanian judge and a president of Kaunas Regional Court, and the court that deals with civil and criminal cases, both as the first instance as well as the appellate instance court. The regime is quite similar, like in Poland. Usually the cases start at district courts, then the appeals go to regional courts, and the cassation to the Supreme Court. But for some specific categories of cases, they start directly in regional courts, and in such cases we act as the court of first instance, and then the appeal goes to the Lithuanian Court of Appeals and the cassation again to the Supreme Court. So both the spectrum of cases categories as well as the diversity of the proceedings are the largest and most complicated in regional courts. And my function include not only the organization of court activities, but also the administration of the activities of district courts operating within the territory of Kaunas Regional Court. And at the same time, I'm also a member of Lithuanian Judicial Council, and for several years I was a national representative at the European Network of Councils for Judiciary, where we were working a lot on various topics on organizational activities of courts. And due to the performance of those different functions, I encountered the case weighting system in various aspects, both in implementing existing procedures and contributing to the creation of new ones. So I'd like to share some of my insights, starting with the concepts, because concepts are always important, because we have to have the same understanding of what the case weighting system means. And the CPEJ back in 2020 provided that case weights assign different weights for different types of cases to account for variations in complexity and the need for judicial attention for each case type. And by doing so, case weights indicate how much more or less time-consuming one type of case is compared to other types of cases. But the question is, what's the purpose of such comparison, and where the case weighting system is to be used? And this is exactly the problem we faced in Lithuania when back in 2021 the newly elected Judicial Council named among its main goals the determination of the optimal workload of a judge. And when we started implementing this goal, we realized that we had a very different understanding of what this concept meant. And the case weighting system itself is only a tool whose content and functionalities depend a lot on the purpose we use it for. And I would divide the purposes for which we use the case weighting system in Lithuania into three main categories: the distribution of cases, the optimization of resources, and the evaluation of performance. An advanced electronic court information system, LITECO, has been implemented in Lithuania since 2004. And after a series of improvements, which are also currently underway, LITECO is used not only to register cases, but also to allocate each case to a specific judge by electronic means using algorithms. And there is no doubt that the number of cases assigned to a judge does not tell everything about his or her workload, because the complexity of different cases varies significantly, and there is where we need the case weighting system. Moreover, in the last few years, amendments to procedural laws were introduced, granting to the president of the higher court, who carries out the external administration of activities of lower court, the right, after determining significant differences in the workload, to transfer both civil and criminal cases from the court to which they are adjudicated to another court with the lowest workload. And as practice has shown, the weight of the case is important criteria, not only when comparing the workloads of different courts, but also when deciding on the number of cases to be transferred. Well, simpler cases that do not require oral hearings are the first to be transferred, so the proper assessment of the weights of each category of cases becomes essential. Now, speaking about optimization of resources, when a decrease in total number of cases was recorded for several years, starting probably from 2015 or 2016, and the politicians began to use this as an important factor in the negotiations on the financing of the judicial system, saying that, well, less cases means less workload, while the number of judges is not changing. So there was a need to analyze in detail the structure of the number of cases, the reasons for the decrease in numbers, and the impact of that decrease on the workload of judges. So should we make changes in the court network, or adjust the total number of judges, or on the contrary, should we gather arguments for a discussion with the social partners and politicians that the system is efficient enough and the internal reserves are exhausted? And last but not least, workload is also one of the 4 evaluation criteria of a judge's performance, together with the quality of decisions, the duration of proceedings, and organizational skills. And we can see that, well, absolute numbers of cases differ significantly. But sometimes it is determined by objective reasons. For example, the specialization of judges. In some categories of cases, depending on procedural requirements, are much more time-consuming than the others. And so the question is not whether the case weighting system is necessary. The question is how to make it as effective and suitable for our needs as possible. And the starting point was the LITECO system, which is very statistics-friendly, because all the proceedings-related data is recorded, including documents, evidences submitted by the parties, data on number and length of court hearings, as well as all the documents produced by the court. And this was one of the reasons why this Delphi, or calculated estimate method of data calculation, has been chosen as an alternative to the so-called time study method you talked about, which is used, for example, in Austria or in Germany, where judges are asked to fill in a form with the data regarding the actual time spent handling different categories of cases. And the weights of different categories of cases are set, taking into account the results of the analysis of such empirical data? Well, in Lithuania, by means of expert evaluation, we compiled a list of different groups of cases, as well a list of different relevant elements of each of those case groups, and used the statistical data from Liteco to set the weight of each case group. And in this way, well, assigning a relative weight to a certain case category made it possible to determine weight proportions between cases of different categories based on these statistics, which were further evaluated and set by experts and then officially approved by Judicial Council. And the Liteco system was programmed in the way that at the moment the case is filled, it has to be assigned to one or other category and carries the weight of this category. And during the distribution procedure, the algorithm calculates the workload of judges based on the number of those weighted cases received by each judge in the reference period of last 90 days. And the new case is assigned to the judge with the lowest workload. And soon, actually, an obvious problem was encountered with that. Well, you know, statistical averages are called averages because they do not always reflect the reality. And the time required to examine, let's say, 2 civil cases arising, for example, from the contractual relations belonging to the same category can be very different. Because, well, in one case, the judge can simply refuse to accept the claim because of some procedural deficiencies, or the parties can conclude a settlement, and in another case, it may be necessary to hold several hearings, to have expertise, to apply to the Constitutional Court for the clarification of legal regulation, and to produce the judgment itself. But in the system used, such different cases belonging to the same category bear the same weight. And as a result, it was decided to create a system that would allow to individualize the weight of the case in the course of the proceedings. After weight is assigned at the moment the case is filled, well, changes from the established average were allowed to be made by uploading significant data into the Liteco system, such as like the number of parties, the number of requests or demands, the number of volumes, the number and duration of court hearings, documents prepared by a judge, and even the time spent on their preparation. There are like a technical tools to do that. But such upgrade, again, revealed problematic aspects. And on the one hand, the 90 days reference period used for the case allocation procedure usually is not enough to resolve a complicated case. And this is why it was decided to create a so-called dualistic system, where for the purpose of allocation of cases, we stick to the usage of the weights of cases filled during the reference period, this 90 days period, and for the purpose of assessing the workload of the courts for efficiency reasons, as well as evaluating the judge's performance, we chose to weight the cases resolved during the reference period, who is usually longer. It's a 1-year period. And again, this dualism often brings confusion because, well, the results of calculating of the workload of the same judge when based on different criteria can vary significantly. On the other hand, well, certain cultural and mentality aspects were also revealed, which showed that it would be difficult for now to adopt in Lithuania this time study or empirical data-based method. Well, the problem is not only as the colleague said, the complexity of the collecting and interpreting such data, or the fact that implementation of such method itself is time-consuming, but also the negative perceptions or clearly offensive attitude of the judges, who view every initiative of an administrative nature as a threat, interference into their independence. And therefore, when they were given the opportunity to make the records in the Liteko system themselves, they were uploading exaggerated data to show how hard they work. And even with some clear cases of abuse or distortion of statistics, uploading clearly inaccurate information and hoping to make an impact on the real workload. And for this reason, in 2016, the possibility to individualize the weight of a specific case was abandoned, and leaving those average weights approved by Judicial Council. Now, another feature of the case weighting system used is points or benchmark based, which determines its limitations. First of all, well, maximum efficiency can only be ensured if exact proportions of weights are determined between all categories of cases in all courts, all levels and instances. And in our system, the idea was that for cases allocation and workload balancing purposes, we don't need comparison between courts of different levels, or even between two major specializations, the civil cases and criminal cases. And for this reason today, well, having data that the workload of the judges of the criminal cases division of Kaunas Regional Court is higher than the average of the workload of all the criminal judges in all the regional courts, and at the same time the workload of civil judges in Kaunas Regional Court is lower than the national average of all the civil judges working in regional courts. This data is not enough for me to conclude that judges of the criminal division of my court work more than the judges of civil division of my court, and make relevant organizational adjustments without further analysis. And in my personal opinion, it's a clear deficiency of our weighting system, and those weight proportions have to be universal throughout the court system as a whole. At the same time, this benchmark or relative values based system does not answer the question of whether the judge's overall workload is high or low. It's only proportions. Right? They are not aimed at calculating the aggregate judicial working time required to process the number of incoming cases of different case types, as is with time units like minutes or hours based weights. And therefore, when the goal of calculating the optimal workload of a judge was set in 2021, the need to relate the weights of cases to the time required to hear a case of different categories became apparent, so that after evaluating the average length of a judge's working time, a conclusion could be drawn as to what number of cases would be optimal. And for now, this change is in the implementation stage. It applies only to district courts and is being tested in practice in several pilot courts. The idea is that, well, having all the categories of cases weighted using time units-based weights that are periodically reviewed using statistical data would significantly expand the range of systems utility or usability. And having data on the weight of each case, as well as on the total weight of all cases received and resolved in the court during certain period of reference, or total weight of cases resolved by individual judge, we can ensure effectiveness of the case allocation procedure. In the process of optimization, objectively estimate the number of judges and court staff members required, as well as evaluate the working results of a specific judge. And these are the goals for nearest future. Thank you.
Pięknie dziękuję za przedstawienie.
Thank you so much for presenting a Lithuanian experience in weighting cases. Well, now we are coming to an end of this panel. So now we have time for asking questions. So please raise your hands, those who want to ask questions, and then our guests will give you answers. Are there any questions? Yes, please, Judge. Thank you so much. I can't hear, unfortunately. The mic is not on. So once again, Andrzej Sowiecki, District Court for the Capital City of Warsaw. I have a question to Professor Walasik. You have how the system of weighting cases, if all these figures are entered into it, so when can we have a kind of equalization of workload in Poland? Because now the situation is such that we have a certain specific number of judges limit. Some just retire because they are too old. And if we decide that some courts need more judges, other fewer judges, so how could we cope with it so that not to have this balance in a dozen years or so where people leave courts and you cannot, without any limits, add new posts? Yes, of course. There is no exact answer to such a question. We do realize that the process of creating the system and then implementing it requires time, and we are now at the time stage when we have to start working on it. That's why we put pressure on it. So they take into account that the possibilities of the kind of nominating system presented within the few last years. So it turns out that in a short time, the proceedings ending in appointing judges take a short time, and that refers to thousands. And if the system really shows that there are not enough human resources in courts, then quite soon we would be able to resolve the problem. But the main problem is that we still don't have a tool that would enable us to make such diagnosis, and now we are at the stage of debating on how the instrument should operate, and this is the first problem that we should overcome. Thank you so much. Now, 1 more minute for asking question. Please be brief in your questions. Tomasz Zawiślak. I have a question to our guest from Lithuania. I wanted to ask about two things. How long did you take to prepare this system of weighting cases? How much time it took you? The second question is how judges approach the system. Is it accepted commonly by them, or are there any criticism about the system of weighting cases? Yes, President, now the floor is yours.
We're not at the end, I mean, of the implementation, because we start to use it. We are using it more than 10 years already. The different variations of it. Now the new one that we started discussions on, because as I've mentioned, we had the one that allowed us to help in the allocation procedure, but it was totally unhelpful when deciding upon the resources. And we started discussions in 2021. Right now we are piloting, and only in one level, the district courts. How will it be? I'm not sure. Now, speaking about the judges, well, if you would ask my personal opinion, I would choose this model of empirical data collection that we didn't choose. We went the easier way. And this is where the judges are very threatful, and they don't want to participate in this, how to say, empirical data collection procedure, where someone asks a judge to sit and write, how long does it take for you? When we did it, allowed it to do in the system, they were writing for writing a judgment, it took for me 100 hours. And that was an impact. The others didn't care about that, and it made the statistics it disturbed it. So it doesn't have to be like a permanent issue when you check every case, but to find out what would be the average weight of a specific case group. You either choose the experts, some judges who are joining into the group and discussing what are the most important criteria and what weight should be given to one or the other criteria, or we should collect the data empirically. So nobody wants to collect it because everybody thinks that, well, they will find out that our workload is too low. And in Lithuania, we have a discussion that the total number of judges has to be reduced at least by 10%. Discussion. And during those discussions, we are trying to show, by using this case weighting system, that well, it's how to say that the plain numbers doesn't show what the real situation is. That there are some reasoning behind that, and this, if it's created in a good way, that's a really important and helpful tool.
Dziękuję uprzejmie.
Thank you so much, ladies and gentlemen. One more question, the last one. Is there anyone who would like to ask a question? Yes. I'd like to ask the question which is related to the fact of efficiency of courts. It depends on the cognizance of courts. I don't want to historically to remind you of how this kind of hearing case was extended and whether it should be done in the courts. So whether in parallel to weighing cases, there is work on really examining the hearing of cases and whether these cases should actually be resolved by courts. And then auxiliary professions in courts? Is it taken into account? So all professions that participate in the judiciary work should be taken into account, because much depends, or efficiency depends on the work of barrister, advocates, or legal counsels. So, well, and this is the work which is also to motivate these auxiliary professions. And we don't have here with us Mr. Markiewicz, but is it necessary to make changes in procedures? Because if we extend the powers of parties, that was the computerization of the register, because there was before that kind of claim or appeal against it. As for the cases of judges, well, that would take too much. So wouldn't I say that this system of subjective rights is not too extended, because it really causes cases to be long. So whether we are maybe not taking into account the deeper reason of various late. So whether in parallel to all these case waiting cases, is it really sad why courts are late? Every year in Poland we have 500,000 new cases, 14 million. Over 14 million cases are resolved every year. Is that sort of that our Polish people are so liking going to courts, or whether the laws are not well formulated? And what about this kind of legal professions? Are they helpful or not? Do we accuse, or do we defend, or do we let's say extend various court proceedings using various trial traps? Thank you so much. As for the first and third questions, I would ask Professor Walasik to give answers to them. As for question number 2, Michał Jabłoński would answer it. Now, Professor, the floor is yours. Let me be brief. As regards this social draft laws, we did not deal with the change of trying cases by common courts of law, or proposals of reforms in particular court proceedings. That was beyond our mandate and, well, time and organizational possibilities of the team, because it was a very limited team. But we are all aware of the fact that as regards the character of cases resolved by cases, here the situation should be reviewed with the view to normative aspects. As for particular court proceedings, we may expect that the work of the Codification Committee for Criminal and Civil Law will definitely deal with these issues. And now, Doctor, thank you. As a representative of one, say, auxiliary professions, that is barristers, I would say that some of us really cope with that. So we do measure our time and our resources, but it is not reflected in procedural regulations concerning, for example, the costs of court proceedings, of costs of trials, costs of legal representation as provided by barristers and legal counsels. So these rates which are weighted, I mean, for taking part by this professionals in proceedings, and they are taken into account in the legal representation costs. They do not reflect the reality at all. These are fictitious costs. And in the majority of cases, they are much lower than the real cost of the workload needed for particular cases. I'm not saying that this is the precondition for someone's remuneration. No, because in market terms, the client pays as much as he agreed on with a legal representative. But then what is the motivating factor for courts, but not only for that, but first and foremost for the parties so that not to go to court, so that to resolve it earlier, so that we don't have, let's say, 8 years for resolving it, and that the whole workload of legal representatives is not reflected in a minimum way what is paid by the losing party. We know legal system is completely different. It's organized in a different way where people do not feel like going to court for that reason as well, because they know it costs. It is a kind of translating some economic factors into reality. I know that there are situations that someone should be released from this cost because someone should not be taken away the right to court, because the barristers of the other advocates would require a high remuneration, but it must be ensured. But if we don't take into account the workload of auxiliary professions, then we would have what we have now. So that, for example, the respondent does not want to agree with the claimant whether the case takes 3 or more years. It doesn't matter to him. That's it. Thank you so much, ladies and gentlemen. Before I sum up our panel, I'd like to thank, on behalf of the Association of Polish Judges IUSTITIA, the Wolters Kluwer publication for the publication of all these social bills on the reforms, and I'd like to thank them for issuing our reports on the statistics of the justice system, as well as the reports on the repression suffered by the justice system within the last 8 years. So thank you very much for these publications. Yes, applause. So to sum up, we heard first and foremost that only the case waiting system is the sine qua non condition for the modern, rationally managed judiciary system. And we heard that it is a very, very hard work. The judge told us about the experience of the Lithuanian system. He also indicated that the system must be monitored and improved. But this is the only possibility to have a modern, digitized judiciary, and this is the only way to success. And if we remember about that justice is done too late, is not this justice, then we are able, thanks to our hard work, by extending our possibilities, capabilities, and acquiring new skills to implement the system, so that the citizen has ensured a unified right to court, access to court, regardless of his place of living, of his residence, so that the courts could be more effective. As a citizen should wait for a shorter period of time for resolving the cases. So thank you very much, the lecturers, and I thank you all participants. And now let's have a coffee break.
Dzień dobry Państwu. Przypadł mi udział.
So I have the pleasure and the honor to facilitate the last session today, which is very important, concerning the regulating the status of judges appointed by KRS, by the Council in the years 2018-24. I would like to welcome warmly our foreign guests. Mrs. Henryka Mościcka-Dendys, the Vice Minister of Foreign Affairs. I would also like to welcome our MPs and all the people who decided to take part in our conference. As I said, it's the last panel, but not least, in order to regulate our judiciary, we need to also take into account the impact of changes introduced into the law on the judiciary and on the Judiciary Council. It did not fulfill European criteria, so we have a package of ideas. I have those ideas in this booklet here. On the one hand, we would like to restore the rule of law, consider again and take into account all the rulings of the European Court of Justice, and on the other hand, ensure stability, legal stability for our citizens. So all our actions aim at those two aspects. I would like to welcome warmly our panelists, Professor Marek Safian, who is with the Warsaw University, the Institute of Civil Law. He was the pro-rector of this university. He was dealing with European law. He was also representative of Poland in the Bioethics Committee of the Council of Europe. He was a member of different scientific bodies. He was also the head of a constitutional tribunal till 2006. He was the president of this tribunal. Great case law jurisprudence of that time, very useful for common courts of law. In 2009-2024, he was with the European Court of Justice. He was a judge there, and he had a great contribution to the European case law and jurisprudence, and he is now member of the Codification Commission of the Civil Law. The second panelist is Professor Piotr Mikuli, the head of the Division of Comparative Law at the Faculty of Law in Kraków. He is dealing with the constitutional comparative law, and recently his scientific works have concentrated on the role of executive power in Europe. He's dealing with Central and Eastern Europe. He is a scientist cooperating with Leicester University. He's been taking part in common projects in Sheffield, in Glasgow, Oxford, and in Sweden. In 2022, he implemented a project on the status of judge in modern state, and in 2018, together with his team, he implemented a project about the position of the judiciary in the division of powers in light of changes in the constitutional law. I have listed projects that are directly linked with the judiciary, of course. There are also other projects. And the third panelist, Krystiana Markiewicza, representing the Silesian University, member of the IUSTITIA Association, author of different publications, legal publications, officially the head of the Commission of Courts and Prosecutors' Offices. So we hope that he will contribute to introducing legal changes aiming at restoring the rule of law and at transforming our judiciary into a modern system, ensuring proper legal protection to our citizens. The first to take the floor will be Krystiana Markiewicza, who will present the assumption of this law prepared by our association. Thank you, Judge. This book is quite big. It has about 800 pages, so those are very detailed documents, laws, and fundamental, though, for the functioning of our judiciary, our courts and prosecutors' offices. But the fact is that the majority of people were waiting for a shorter law, which will help us deal with what happened during the last years, so about appointing judges, wrong appointments of judges, what to do with neo-judges, so to say. So it's based on 3 panels. Our conference is based on 3 panels, and the first panelist is usually, his role is as a co-author of an draft, is to present this draft, and then of course, the rest of the panelists can do whatever they want with this draft. Then they can keep criticizing this draft. It's a draft. It's already made, a draft with a justification. But we want to be fair from scientific point of view. So in the framework of a debate that has been taking place recently, we presented some assumptions concerning a different approach as the one that we have now, which is based on the vetting system. The vetting system would consist on analyzing every case separately with the commissions, appeals, and with participation of the Supreme Court. So we adopted as a basis for our draft the fact that it should be based first of all on European and national regulations, the requirements concerning what is a court based on binding law, and that we should base ourselves on international experience, national experience. Let's start from international experience. We've invited many specialists, experts, invited by our foundations and associations, and it results that from the statements of many specialists, the vetting does not deal with the problem of effectiveness. It was about dealing with corruption, for example, in Ukraine, Albania, South American countries. In our country, the problem is different because it concerns vocations, appointments. If someone was well appointed or it was a wrong appointment. Secondly, such a process involving individual vetting would take probably some 20 years or so in Poland with the judges, judging judges. We have 2,000 judges now, so the overall reception will be that judges are judging judges and they are dealing only with their own matters. They should be dealing with the citizens. So this would be compounded by disciplinary processes based on the same grounds. And thirdly, such individual verification on such a scale has never succeeded in Poland. This is what the experience has shown. So if we had to sum it up, it seems, and we are convinced about it, is that the only way is to have a general approach, global approach from the legal point of view towards those neo-judges who shouldn't have been appointed. We started from the assumption that the problem is not about who is a judge, what moral or substantive qualifications he or she has. We only have one problem. Is it a court established in accordance with the law, which means in accordance with the Constitution of the Republic of Poland, and does it fulfill European Union standards in general? Finally, what's important? The right of access to the public service in European terms applies to everyone. The vetting project focuses primarily on those who choose to break the Constitution, not to respect it, on assessing whether they broke it more or less, what were their motivations, rationale, or some other criteria. This is not transparent enough. But we forgot about those who decide not to violate the constitution and did not run for elections. They didn't want to be appointed as judges. The best ones, in fact, did not present themselves as candidates. So they should also be given the right to take part in the competition so that the best ones win. This is not just so, and even especially it's like that because they should be guaranteed this right. Everyone has the right to a court according to our constitutions, according to EU law, and not to any court, but to the best judge, the one who wins in a transparent and real competition, and not the one who breaks the constitution. For example, someone goes to a court, files a case, meets a judge, and then it turns out that this judge did not respect the constitution principles. So we should expect really much from our judges. So here, the the bill is called the law on regulating the effects of the resolutions of the National Council of the Judiciary adopted between 2018 and 2024. It's the title of this law that is very important. Because it's not about discussing the situation of individual judges, but the problem was that there was this National Council of the Judiciary, which was a political body which was shaped against the Constitution, and its composition was against the Constitution as well as its functioning was against the Constitution. And it has been confirmed by rulings of Polish courts, but also by European courts, by the European Court of Human Rights. It was during the pilot year, the case Wałęsa against Poland. It's really symbolic that in this symbolic year and that there was a case concerning our former president. If you want to be a country of the rule of law, let's not choose from many decisions which ones should be applied. All of them should be applied if something was ruled. The solutions adopted in our draft define these effects as proportionately as possible, I think, taking into account the result of balancing the different and conflicting values that must be taken into account. On the one hand, it's necessary to guarantee to the parties and participants in the proceedings that their cases will be heard by an independent and impartial court established by law. On the other hand, we gave the right to a court to have the stability of final judgments, final decisions. So the basic two assumptions were as follows. Those wrongly appointed judges get back to their previous position. And secondly, rulings will only be exceptionally shrugged off, thus ensuring their essential stability. Because the aim is to restore the state of affairs in accordance with the Constitution of the Republic of Poland. But at the same time, we don't want to take revenge on anyone. The proposed law contains comprehensive regulation of these issues. In view of the loss of constitutional identity of the National Council of the Judiciary, resolutions adopted with the participation of judges elected as members of the Council by the Sejm of the Republic of Poland on the presentation of a motion for appointment to a judicial post are deprived of legal effect, so that the decision of the President of the Republic of Poland on the appointment of the office of a judge of the persons indicated in these motions do not have the effect referred to in Article 179 of the Constitution. Secondly, the restoration of the right to an independent and impartial tribunal established by law requires the rerun of judicial appointment procedures procedures terminated by resolutions of the Council. Thirdly, the retrials should be open to persons who were previously appointed as a result of the retrials, those near judges, provided that they maintain their application for appointment. Participation in the trial makes it possible to subject to judicial review the retention or loss of the position held when the law entered into force. We have 2,000 judges, so it's a great number of people. In order to preserve the smooth functioning of the judiciary during the period of reopening of proceedings, a system of secondment of judges of common courts to the courts in which they held their position on the date of entry into force of the Act is envisaged. And then, finally, parties to proceedings who have raised objections to the impartiality of independence of a judge resulting from his or her appointment at the request of the current council should be able to challenge rulings made with the participation of those judges. So there shouldn't be any harm done to anyone. So there should be this right of objecting. According to Article 179 of the Polish Constitution, judges are appointed by the President of the Republic of Poland on the motion of the National Council of the Judiciary. This means that the system of appointing judges is a limited system. Both conditions need to be fulfilled. So the National Council of the Judiciary, this motion is needed, not a motion of any other body. And then also the appointment of the President is necessary. Meanwhile, the change made by the law, which was adopted, namely in this building in 2017, the principles of the constitutions have been broken. And as it was said, this panel is illegally shaped. It's against the constitution because judges shouldn't be choosing judges. So the council has nothing to say. What is really interesting, what was avoided in the Polish doctrine, if there is no motion for appointing a judge from an authorized body, there is no effectively appointed judge, in fact. Article 2 of the draft clarifies that those resolutions have no legal effect. This construction allows to take into account the fact that appointments made by the President are not real appointments of judges, and professional relations they entered into as judges were not in fact real professional relations. So this is a key thing. Of course, there are exceptions to this rule, and exceptions concern two categories of people. I'm talking about, namely, young judges who the situation was different because there was no competition for them before the council. The Council of the Judiciary was just a mailbox, so there was no competition. There was only transfer of powers. So the regulations concerning appointments did not have any effect. Secondly, about people who passed this judge exam, according to the law, there was a deadline which was set for them that they could present themselves as candidates for this competition. So we considered that the situation was that they were forced to do so. So it's also an opportunity for the court to drop this case. It's also important because it's an obvious gesture towards those young people, not to some individuals, but to some 30% of newly appointed judges from regional courts. It's of great systemic importance. So the draft law, for now it's a draft law, it's addressed, and let's say it clearly, towards those who have chosen their career consciously against any principles set by the constitutions, because each and every one of us has the right to a court according to the law. As an effect of the ineffectiveness of those appointments, there is a need for reopening competitions, and those competitions will be announced by the Minister of Justice. He will be able to consolidate competitions so that there are no 10 competitions in one court.
So if the judge says, I want to take part in the competition, he would automatically take part in it. So everyone who complies with the requirements will be able to take part in the competition, and the best should win, not the one who was the candidate at the time because there was no other candidate and he was not suitable for the position. No, the best should win. So as for the status of these people whose official relationship is not considered established, as regards people who are, I don't know, barristers, legal counsels, they may return to their profession. That's our draft. As for judges, they would go back to their previous position. So let me remind you that there is 2-year statutory secondment, so that the proceedings would be smooth, so that they could first finalize the cases they started, whereas the president of the appeal court may re-exonerate from this statutory obligation, because if he sees that the person does not comply with any criteria, it's really an offense to the justice system that such a person is part of that system. So, well, we may return such a person to the previous position. So that's why we have 2 years, so that the president who is responsible for administering justice would really assess himself when people are returned to their positions, so that to ensure people right to a court. There is one more solution which should be emphasized, that such a person would participate in the competition. This is the so-called neo-judge, and after 2 years have passed, then with his consent, the person may still be there on that position. It's a good judge, for example, he is very likely to win the competition, and then such a decision on such secondment could be taken. And finally, as I've already mentioned, we are protecting the stability of judgments. They are still final. There are detailed specific regulations for civil law cases or criminal law separately, which make it possible to challenge those judgments that were given with the participation of wrongly appointed judges, if, of course, someone made such reservations earlier. Not that it's now, after 7 years, that people will become courageous, and they were not earlier, and then they will start challenging for 1 million judgments. That's briefly it, because I guess I've already beyond my time. So thank you very much for presenting the effect of this pertinent law that you've been discussing. That is the effect of the appointing judges by KRS in the previous period. And you discussed how these provisions would be extended, and what is the justification of the provisions, and what you said about the people who are unable to adjudicate in this court because they were appointed wrongly, and that's why the president of the court will exonerate them from that court. And I can tell you, as a judge in the appeal court, I must say that we have such judges in our department that should never adjudicate. Now let me give the floor to Professor Piotr Mikuli from the Comparative Law Faculty of Law and Administration, Jagiellonian University. Thank you so much. First of all, I'd like to thank Professor Markiewicz and IUSTITIA Association for inviting me to the conference. and for giving me an opportunity to comment this draft. So far, I've mainly discussed the problem of neo-judges in Poland abroad, and I had to clarify or explain the complexities of these laws adopted in 2017. So thank you so much, therefore, for inviting me here. I will refer to what a professor has said, but as Madam Professor Moniki Florczak-Wątor, I'd rather focus on some general guidelines. I wouldn't go into detail, but before I discuss it, I'd like to first refer to some theoretical aspects. That is, we've been thinking what to do with the so-called neo-judges since 2018, where, let's say, this institution, unfortunate institution, was established. And immediately, various seminars were organized, as well as conferences, at which we envisaged that there would be a time when we would be able to implement our ideas of repairing of the justice system. So I remember that there are some draft laws of the Senate which are aimed at resolving the problem of neo-judges. But these drafts should be evaluated through international jurisprudence, that is European case law. The Senate draft was conceived very early, where nobody was, not all were convinced that we could say that we have the category of neo-judges. That was what was said was that there was a defect in appointing such a judge. The Senate draft law used the word judge here, so it was criticized, and we can explain it in such a way that at the time we were not fully aware that the violations of international law or European law and constitution are so serious that we can treat the institution of the neo-judge as the completely inadmissible institution, and therefore the IUSTITIA draft law it fits with the whole context of that. So I'd like to again really put forward a thesis, and I always mention it when I discuss the improvement of this constitutional situation, of this situation of the judiciary. So various legal drafts are not yet a normative law. All these, let's say, drafts are, in my opinion, still acceptable in a democratic state of rule of law, and we don't have to go to the justice of the so-called transitional period. Why do I think so? Because some principles of justice of the transitional period are used when we have the transition from the authoritarian to a democratic system, and this authoritarian system was not assessed through various constitutional models or international standards, because it was authoritarian, like in Russia now, or it could be part also maybe formally of some institutions, conventions, but this is not effective. Its nature is just formal. Therefore, under the after or within this transitional period, when we get rid of the authoritarian system, we use mechanisms which are not acceptable in a normal democratic state of rule of law. Of course, in the authoritarian system, the power is held by the elite or an individual, and there is the problem what to do with the judges of such an authoritarian state. Of course, in the world there have been different solutions used here, but these solutions were introduced by a certain entity which out of the sudden gets democratic legitimacy, some kind of this is institution or institution that has a moral legitimacy to act in the name of a new state. Well, the situations differed. Either that was revolution, maybe also more radical or less radical, or velvet resolution, like in our part of Europe. Well, we just gave up the authoritarian side, and there was transition to the democratic state, and then we don't have to apply this rule of non-removal of judges. We may say that the authoritarian state judges are not judges, and the new power says that. And here, the Polish state, after 2015, was aimed at authoritarian state, was going in that direction, but the authoritarian system was not built because it needs time. So how, from the viewpoint of the theory of the constitutional law, we can look at the system which has been shaped from 2015 to 2023. Here, of course, there were different looks at this particular issue, but I like to refer to the concept of a double state, which was very much promoted by Professor Łętowska. So in a double state, we have institutions taken over by autocrats or politicians who are aiming at removing liberal democracy, and we have institutions that has defended themselves or are defending themselves, such as Constitution Tribunal, and then throughout this 8-year period, judges and courts were defending themselves. But in the double state, there are some legitimized and democratically and constitutionally institutions that may assess what's happening in the institutions taken over by politicians. We have the jurisprudence of the institutions which were not taken over, which pertains to the issues of the judiciary and the new judges. We have some resolution of 3 chambers. We have, of course, also the European Court of Justice resolutions, etc. So these are institutions that are authorized to give binding judgments for the state. So if we have to resolve this topic of new judges, we have to apply the binding judgments issued in Poland and abroad. So we don't have to use any extraordinary concepts. We don't have to refer to the concept of the transitional period justice. We must just implement this jurisprudence. The question is how. So generally, as Professor said at the beginning, there are 2 looks at the beginning. So generally, we resolve the problem of neo-judges or individually. So each solution has its defects. So Iustitia is supporting this general solutions. Part of lawyers, part of my colleagues are more in favor of an individual approach. These people claim that individual approach is more in line with EU case law, that you can just between the lines read that such approach would be more suitable. So the question is, what is an individual approach? So there are 2 solutions here. Either this is disciplinary responsibility, and the Senate draft law was aiming at that several years ago, or it could be something like the overall assessment, which to some extent may remind us of vetting, as Professor already mentioned, and this vetting might be accepted to some extent, but the question is it really adequate for us? Because the basic sin, let's say we can say, of neo-judges is that they took part in this non-constitutional procedure, whether they were related to the ruling party or not, whether they were more or less honest is important, but for the status of the neo-judge of secondary importance. If we are to assess individually neo-judges. So which criteria should we use? That, for example, that the criterion is that they took part in the competition. So how different is it from the abstract assessment? If we do vetting, that we may come to the conclusion in an individual case, although the person took part in the illegal competition, but had merits, he had or she had scientific achievements, was not very much related to the ruling party, and may stay there. But as rightly pointed out, Professor Markiewicz also and the Judge Gonciarek in one of his interviews said that what verification means, but those judges who did not take part in the competition then, that they already lost a lot, because in this case we may establish it would be an independent judge, but he won that competition because the others did not decide to participate in the competition for moral reasons, or they heard the appeals of legal counsels or barristers appealing to them not to take part in the competition. So maybe the person who is not at a high position won the competition, has gone through verification. He or she was not really very much politically involved. Maybe incidentally he or she did not resolve the cases, the case which would be very sort of important, especially very much exposed by media. So after verification, he or she will stay there. But this is the defect of the individual solution. But it doesn't mean that Justitia's solution is faultless. First and foremost, because the group, about which mentioned the professor, 2,500 plus, is a very diverse group. So this draft is good for young judges. Problem, let's say, that was already explained today. In a sense, it somehow protects the justice system, because neo-judges who before unconstitutionally appointed were judges, they stay within the system, or they may also be still seconded. But the question is, how many neo-judges we have, those who were not judges before? That's the question. Because there were such persons, I know such persons, they were not necessarily legal counsels, barristers, but they may have complied with the conditions of being appointed because they were professors. This is a small number, but in the case of barristers or legal counsel, it is a certain number. So they will not stay in the system. So these issues, this is like that. These cases they deal with must be referred to someone else. Well, the question is how to resolve it. And of course, in order not to dwell on it too much, I'd say that the draft law is very promising. Generally, I'm closer to the concept of the general, overall, systemic solution of the problem of neo-judges, but it requires still discussion and more detailed elaboration. So thank you so much. So, thank you very much for your scientific look at it and to take into account various perspectives. I'm very happy that, Professor, you paid attention to lots of my colleagues, judges, who behaved in an honorable way, who didn't want to take part in the competition from 19th November 2019. After this case being resolved in the Court of Justice of the European Union, they knew what was going on. And we must tell our foreign guests that between 2016 and 2018, in my department, 1/3 of judges were missing and competitions were stopped because then the political power was waiting for a new KRA. So this is even longer period of time for waiting for being able to take part in the legal competition procedure. So thank you so much. We do realize that all these solutions have some defects, but maybe later on you will ask questions to Professor Markiewicz. So now Professor Safian, Professor Milkiewicz said that between the lines of the tribunal, of the judgments of the tribunals, we may deduce some things. I wonder what is your opinion on that. Thank you very much for inviting me to the very important debate. Let me start with a thesis which seems controversial to many people, including professor as well. And in my opinion, we are in a more difficult situation than in 1989. In a way, more difficult. Why? Because if we are in a situation where we can have a clear demarcation line, okay, we will start from zero by building some institutions that did not exist earlier, did not function in the system, then we have a bigger room of a maneuver. But what happened after 2015 is a picture of a completely different situation. That is creating kind of the spurious state of rule of law. That is that by establishing that the institutions already function in the state of law, but they are somehow devoid of the content. So they are, but they do not exist really. We have the Constitutional Tribunal, but it does not exist. We have the Supreme Court, but it starts to change into something which is completely opposite to it. And the same is going on with common courts of law, because some courts start evolving in the direction which has nothing to do with rule of law. And I must clearly therefore state that that was the system, maybe not fully authoritarian, but named by Laurent Pech, a professor who dealt with these issues of changes in legal system in our part of Europe, who said that this is nothing else but kind of election democracy, not authoritarian, but the so-called election democracy. And we know the term which is used here also, non-liberal democracy. It's an oxymoron really, because if something is non-liberal, is non-democratic by nature, it should not exist. So we must remember that if we deal with such a very radical change of the system, with the deformation of institutions, then we face a much more difficult challenge, because out of a sudden we have to restore these institutions. They must be alive, they must get a new shape and content, but at the same time we must deprive them of those powers they obtained in the meantime. So briefly and paradoxically, we must answer the question how, for example, to defend the Constitutional Tribunal, the real, against the very Constitutional Tribunal. It's a paradox. So how to defend the Supreme Court against the Supreme Court? So this is a more difficult question compared to what we were confronted with in 1989. But I want to go into polemic, and I don't want to have another assumption that we can introduce here the philosophy of the transitional period, of the transformation period, because now we still face the dilemma evolution or revolution. I think that generally, I guess, we should not follow the path of revolution, because we live in a state of law. Because today what we want is to restore an important constitution, and not to act against the constitution, to restore the real dimension of law and not acting against law. This was what the Polish judges fought for, so that the law is respected. And therefore we must look for the ways that enable us to preserve that way of thinking. Why is it needed? Just 2 words about axiology of is necessary. Definitely, we must restore to the society real courts and real judges. This is crucial from the citizens' perspective. We must remember that the certainty and foreseeability of law are the values which could be the minimum of the requirements for law, even within the meaning of lion followers. So this is the minimum requirement which should be respected. So today the minimum requirement for even the formal approach to law is not complied with, because we see very kind of strange patchwork situations composed of different ingredients, which maybe create an interesting picture, but for average citizens very dramatically difficult, because non-foreseeable. We must build the new judiciary, because if it's well adapted to the requirements and standards of our constitution and European law, because we must remember that we live in the world where courts play an extremely important role. Maybe today this kind of progressing jurisdiction is not negative, not pejorative, it's positive. I mean, in most conflicts which are of a court's nature, I mean, this imposes on the judges special duties, that is balancing all the values in the system. So looking for appropriate hierarchies of the principles, looking for right solutions, as Birkin's Hercules, who is to weigh various arguments, and very often conflicting ones, and to choose the one which is best in a given situation. So that requires very good preparation and certainty that we have independent, objective, impartial judges. Let's finally remember about the fact that what is really very important for this perspective of change, and typical of that, each judge today in Poland is at the same time a European judge. I repeat it all the time, is a European judge. So each judge today is not only responsible for applying EU law, but as a European judge, he or she must all criteria related to impartiality and independence of the justice system in the whole European space be applied by him or him. There are no exceptions. We cannot have any exceptions or different interpretations. That is inadmissible. A different interpretation could be done by another president of Madame Przyłębska, saying that Article 19, for example, is not binding. But we, in the state rule of law, cannot afford it anymore.
Is there any alternative for the proposals which are the subject of our meeting? Is there an alternative to what Iustitia has done? Let's imagine that we haven't done anything. We start from scratch. Let's forget the past, and let's not do anything, not to destabilize the situation. Let's keep the status quo without changing anything. Well, I'm convinced that this kind of solution would be the worst one to be applied. According to me, there is no alternative than to just introduce general systemic changes in order to avoid legal chaos and what, rightly or not, was called Doppelstaat. With a reasonable interpretation, of course, we'll always be able to have the right interpretation within the system. But in order to avoid uncertainties, legal uncertainties that the judges have to face, but also our citizens have to face in courts, we need to introduce those necessary changes. It's not that we should act case by case. Let's imagine that it takes many years to proceed cases. It really takes a lot of time. It's something that is a disaster. So what is really...
To oczywiście ramy konstytucji
So the framework of the Constitution, which clearly specifies the standards, we have nothing now which is respecting this division of powers. Within the Constitution, there is this very important resolution of chambers of the Supreme Court, which are brought together already in the 23rd of January. Yes, was it the 20th of in 2020? Yes, on the 23rd of January of 2020. Adopted this very important resolution, which is of great importance now, and which shows which way to go, how to approach the question of what happened after 2013 and 2015 concerning the Council. But we have all the European case law from the European Court of Justice in Luxembourg and the Court of Justice Human Rights, which specifies clearly what is the framework, what should be done. This is not what we can do, but this is what we should do. It's not about deciding or choosing. It's about having to do something. When there is this justification of the decision in this Lech Wałęsa against Poland case, it's very important to read it. Expressis verbis. What was imposed on Poland is to act. There is an obligation to act in order to change legislation, to introduce amendments in order to ensure proper functioning of the judiciary. Article 6 of the European Convention is here of importance. It's clearly stated in this decision. If we read this analysis in the case Dolińska-Ficek against Ficek, or Advanced Pharma or case, or Wałęsa case, and we have the analysis about the Council of the Judiciary and the appointment system, which was created based on recommendations of this unconstitutional institution. So there is no doubt when reading it that there is a clear basis for creating new legal framework. I think that it's a legal framework that allows us to create specific regulatory mechanisms. This obligation results clearly and even clearer from the decision of the European Court of Justice. If it's issued on the 23rd of December of 2023, which concerns the Chamber of Exceptional Controls, and it's based on the fact that all the judges of this Chamber of Control are not judges as understood by the treaties, because they were appointed based on by such a council, National Judicial Council, and this is based on what was said on the case Dolińska versus Ficek, which is quoted many times. So it's a clear action plan, all this. This is a clear analysis showing the unconstitutionality of an institution, which is against European standards, and also a clear statement that it cannot be admitted. So it's a good starting point. In order to act immediately, I'm talking here about the judiciary and the president, so they need to react. I agree with the fact that the way of thinking that you adopt in the draft as an assumption that appointments which are done then are not real appointments according to Article 179 of the Constitution, because of course we can discuss about it and consider it as a good basis for our decisions, but at the same time, we need to stress it very clearly, is that this kind of thinking is, in a sense, something which clearly results, it's an obligation that clearly results from case law. It needs to be stressed really firmly that it's nothing else than executing the jurisprudence. It's an obligation for every member state to respect court decisions. It's nothing else than implementing decisions, restoring the rule of law. Respecting constitutional principles cannot be considered as something against constitution. It would be absurd. We restore constitutional mechanisms, yes. We cannot act against our constitutions at the same time. So if we consider and take into account those constitutional principles, we consider them as the most important ones, and the judiciary is considered as an independent power, one of the three separate powers, which is set forth by the Constitution. So then we will have all the necessary grounds for making our decisions. So as regards your approach, which specifies that there is a need for adopting a global approach and not a step-by-step approach consisting of analyzing specific cases, it would be risky, as I said, and quite dangerous as an approach. So the derogation that could be of some laws, that could be the element of the future law, allows for those people to be desisted from their functions. They would be brought back to their previous positions. And the second part, which is the nomination by president, cannot be understood, and often people refer to it as the implementation of some co-validation process. They often repeat that it's the president who appointed, so it's good, it's safe, and whereas the situation is not natural. Why? Why do they say it? It's not good ground for that. There is a decision from the 19th of November 2019, and it's a decision of the European Court of Justice, and it says that we shouldn't put in question the decision of the president. But on the other hand, people who are appointed by the president are not judges, and they don't have this adjudicatory function. So if we maintain this schizophrenic condition, is that we have such a judge appointed by the president, but he doesn't have adjudicative power from the European law point of view. This doesn't really make sense. President's prerogative is not an arbitrary prerogative that could be freely shaped freely. President cannot appoint anyone for a judge. And this, if we acted this way, we would really destroy the whole system. There was a very interesting conference in Łódź about prerogatives with the participation of Professor Kmiecik about those royal presidential prerogatives. I couldn't take part in this conference. They said there were no prerogatives, but there are competences of the president. Yes, but the competence is not something arbitrary. So this is what it's all about. The status of those decisions and judgments which are issued by those neo-judges. Well, here we enter the field of weighing, the area of weighing those values, those approaches, because we protect a very important value for the rule of law is the predictability of law. We cannot assume that suddenly, due to the wrongly working judiciary, the citizens pay a price for that, for the fact individuals pay a price because they want to be protected by a court. An individual may not be harmed by such processes. It must be clearly said that the judiciary is here to protect an individual and not to harm such an individual. This is one thing. And of course, in some cases, we may imagine, for example, such a possibility of putting in question basic judgments. But please remember that the Court of Justice has frequently stressed in its decision is that a legally binding decision is a barrier, ultimate barrier, and shouldn't be crossed, which is really important. If such a decision violated some European standards and some rules, then this decision was a good which was protected. This contra legem decision also shouldn't be put at stake. So, of course, there are some exceptions that are admissible, and those exceptions are really reasonably generated, so to say. Maybe we should consider such situations where there were some charges, yes, not to create some specific regulations, but we may have the risk that considering the specific charges would really create a need for extending the judgment. So how to avoid this risk of unequal treatment? Because we may not exclude, please remember that we cannot exclude the fact that maybe we need to pay some reparations because the state is responsible in terms of reparations. That's why this mechanism was created by the Constitutional Tribunal at that time, SK 18 in 2001. This was the court decision about illegal normative consequences of some illegal acts. So the question was whether to create some exceptions for young judges, young registrars, people who are forced to do something. This is a question. It needs to be stressed that it's not about in case of registrars, it's not about competitions, it's about transforming their professional relations. So maybe we can find some distinction, distinctive feature which would allow us to adopt a different approach. But we may also say that this second group was forced somehow to take part in this competition. It's a sensitive subject, of course. And this 5 years' time and an evaluation after that, maybe this puts at stake the rule of independence, whether after 5 years there should be such an evaluation or verification of judges or not. I'd just like to add that you may be surprised that I'm not for the institution of an assessor, of a registrar. When I was in the Constitutional Tribunal, we would decide that there wouldn't be such an institution of an assessor, probation for a judge. Of course, we should find maybe another solution. I don't like this one. And another fact to be mentioned is that there is a situation of two chambers of the Supreme Court who have a very specific status of disciplinary chamber and of exceptional control. two chambers of exceptional control and disciplinary, and two decisions were made towards those two chambers that they were not considered as courts. So it was in 21, and this decision was taken, and towards both those chambers, the decisions were made, and they were not considered as courts. So globally, this kind of situation was adopted as regards judges of those chambers. And in my opinion, before we will have new laws, it needs to be mentioned that people who were part of those groups of judges in those chambers, they are not judges anymore now, so we don't need to wait for a new law to become binding. Maybe it's up to the Supreme Court to decide now, for example, that those chambers cannot function as chambers of the Supreme Court because they were deprived of a legal basis for their functioning. One cannot be partly a judge for national cases and not be a judge in European cases. Either you are an independent judge or not. You cannot make this division and have a different approach towards judges who are judges of Polish and European cases. It's a nonsense. They are not judges, that's all. That's the conclusion. So as regards the status of retired judges, here it's a sensitive matter. It's about people who have retired in the meantime, and they got the status, and because of that they get some specific remuneration. Someone was, for example, appointed by KRS. In the meantime, he or she was retired, and he started getting remuneration for a retired judge of a Supreme Court. So, according to the law, such a person should be given her previous remuneration. But this is those are acquired rights, so it's very sensitive. Maybe we should be more balanced about it. Maybe think about adopting such an approach which was valid in the 90s in the Constitutional Tribunal, which was rightly acquired roles and unrightly acquired laws. There are such laws. Maybe those are laws which shouldn't have been acquired. Yes, that's for sure. From the disciplinary point of view, it's for sure. Yes, maybe we should go this way. It should be a good solution. Just to finish, let's not think that we will be able to find a perfect solution today, because in a situation where we are in now, we've been forced to be here and now in such a situation. We'll not find us a perfect solution. In such a forced situation, any solution will contain some gaps or errors, and there will be some constraints. So, and anyone may put it into question. But the value that we should take into account is to look for justice, constitutional justice, and looking for equilibrium between our arguments. And within this balance, we need to search for the proper hierarchy of values. If we go this way, we will be able to find a fair and good solution, as Aristotle said. Thank you.
Do końca tego panelu, ale właśnie są
Right, so we are coming to an end of this panel. Now we have a Q&A session, so please ask questions. The lady first. That will be translated, yes. If it's a microphone is used. So I have a question to you, gentlemen. So taking into account the two positions seen in the debate regarding what to do with the judges, so the leaders of this kind of soft approach is the Helsinki Foundation of Human Rights, which emphasizes the thought that Justitia's solution, get back to where you were, is not in compliance with the European Convention of Human Rights because it violates the rule of non-removing judges. I don't agree with that position, but I'd like your opinion on that. And the second question is, well, we all agree, I think all of us here, that we, face a very difficult situation that would require hybrid or risky solutions or solutions not applied so far. What would you think about the solution, statutory solution, which is an attempt of reconciliating, let's say, water and fire? So we do have the guideline as in Justitia draft, so general solution, you go back where you came from, but at the same time you have possibility of appeal procedure. I have no idea how to formulate it and who is to carry out such procedure, but in fact such procedure could be used for the application of the resolution of the Supreme Court, because then these criteria provided for in the law could be applied to all judges. Well, maybe it's this law is a bit obsolete. Our question is clear. So two questions. Yes. So we have another gentleman who wants to ask the question. Good afternoon. I'm from the criminal chamber. So, well, this is a very interesting panel for me. There are many problems, and I have many comments. But I will ask a brief question. Now, referring to what has been just said, is it so that based on the case of Alina Broda versus Poland, where there is no appeal against the depriving her of the president function, maybe you should think about the situation of, let's say, marking in the law which direction is right. I mean, you should indicate that as regards judges of the Supreme Court, for whom we have the position of ECHR and ECJU, this is automatic. There is no verification based on the resolution of three chambers, because for common courts of law we do have, but we don't have that for the judges of the Supreme Court. So, well, in order, let's say, to diminish appeals to ECHR, because we know it would be like that. Maybe it would be worthwhile to consider the mechanism directly in the law, which would deprive them of the appeal measure, indicating at the same time that we see the problem, but due to the necessity of implementing ECHR, ECJO judgments and Vienna Convention, we cannot have this illegal verification of courts. And perhaps in that case, in the case of the common courts of law, maybe there should be an attempt of depriving some attributes, or that the claims in ECHR should not be too numerous in that respect. Okay, I understand your question, but in a moment answers will be given. Yes, one more gentleman here. Yes, please. Janusz Juszkiewicz, Office of the Commissioner for Human Rights. I have a question to two lecturers. Based on which constitutional provision you see the competences of the Parliament to establish that appointments of judges were not valid, were not right, because, you know, we have ban on presumption of non-competence. So there must be a clear legal basis for that. But in the case of individual verification, we have such a legal basis, because then the court does the final verification, and it has the competence basis in Article 8.2 of the Constitution. And in the case of the Parliament, where we have the Parliament's competence to consider some appointments of judges as non-existent. The second is the secondment of judges as adopted in this draft. So here the President of the Appeal Court could really recall the judge from secondment, and he would get back to the previous court. But there are no criteria, there is no appeal against the decision, there is no time framework. How to reconcile it with the ECJO verdict of 2022, which pertains directly to secondments of Minister of Justice, but it also referred to other models of secondment, that the criteria must be very precise in the provisions by law, and the time of particular judge giving judgments on a position should be given, and it's not here in this draft law. It will be very discretional. Thank you very much for your question. Now, another gentleman and then the judge, because we are running out of time and we would not be able to answer more questions. Yeah, Andrzej Kubiecki. As I'm from the law faculty, the UMCS University in Lublin, I'd like to emphasize that I was against the concept, which is the basis of the draft. And so I have drastic view. There are no judges, no judgments. So I don't use the term neo or quasi judge at the same time, but we don't live in the void, so we must adopt a solution. And from the viewpoint, the solution adopted by authors of the draft law, I think is right. So my question is a different one. So I do agree that with procedural solutions, plus please focus on the fact I don't need on Article 12.4 the responsible of the damages of the state for damages of the state where judgment cannot be challenged. I think in this case it's going too far, but please consider it. You don't have to answer the question now. Judge Żurek. Waldemar Żurek, District Court in Kraków, and so I do claim that there is no removal of these persons from the function because these people were not appointed, because there must be first a motion and most people agree with it. So let me discuss the appeal mode. So we know that these people could again take part in another competition, then there is appeal to the appeal court. But the persons who would not decide to take part again in the competition. Now, for these people, have you considered two modes? So we always use the labor code, and we must state that these people really did work. We may assess it in different manner, but okay, can we interpret first that this relevant appeal based on the labor code to the labor court and later on to the higher ranks. This is one mode which enables the court's way in the appeal. The second question, it's then litigation whether I am a legally appointed judge. We used that institution without seeing, let's say, the final thing. So could these two concepts guarantee these person the right to a court in this case? All right, thank you so much. I understand that Professor Markiewicz will try first to answer these questions. So briefly, first and foremost, please remember that we are discussing the package of draft bills. There are three draft bills. Of course, we do envisage the right of appeal, because if such a person takes part in the competition, then finally the decision is taken by the KRS, and as for resolutions by KRS, they can be appealed against to the Supreme Council. the Supreme Court, of course excluding those people who were appointed in a wrong way, so that we could not have the trial for cases where they participate, and so in Casa Sua. So this is guaranteed. So if someone wants, they really exercise this right to a court. Now let me answer Judges Żurek's questions. Can someone go to the labor court? Yes, of course, he can or she can. So, but the question is what kind of special mode should be used here, because generally it is acceptable. And I don't remember if we had any special modes demanding whether someone is member of KRS, of whether he or she is a judge. And we did it. Hence there are some cases pending in the Supreme Court and also in the CJU. So such right is ensured directly by taking part in the competitions, where and now the competences of the same. Why? Because we live in the state of law, of rule of law. So as for the effects, we did not invent anything here. It can be concluded from all judges, and same as the legislative power had a duty to regulate such a situation based on the judgment. We cannot close our eyes and say, well, we don't know what's going on. And now the question pertaining to the potential violation of the European Convention of Human Rights with regard to the violation of the rule of non-removing of judges. To apply the rule, the person must be a judge. If not, if he's not a judge, then the rule is not applicable. As for the criteria for the decision of the president of the appeal court, yes, it could be considered. And, well, during the debates, some debates, we even thought that it should be a different entity, not necessarily president of the appeal court. So we concluded that it would be an optimum solution. Of course, if the position of the appeal court president would be different now, the mandate would be different. Of course, the discussion is here to find the best solution. All right, thank you so much. So what about the other panelists? Would you like to respond to that? Yes, thank you so much. So the first question concerning the position of the Helsinki Foundation. I mean, I, of course, like very much this foundation, and I'm, in fact, a member of it, now suspended, but I do trust my colleagues from that foundation, but I do not agree with that position, because we deal here with a very clear message resulting from our EU case law and jurisprudence of our courts. It's not only the resolutions of 3 chambers. We have the whole line of such in the Supreme Administrative Court, and we have many judgments of the Supreme Court that show the wrong appointment. Some even state they are not judges. These persons are not judges because they were appointed with the participation of an unconstitutional body. And I think that this position enables us to adopt necessary solutions. Maybe not allows, but really it is incumbent on us. It orders us to adopt it. As regards this is the appointments are null and void. I understand the professor already responded to it. So the fact that the judge is appointed, this appointment is void, is because these persons are not judges. They are not judges within the meaning of the standards adopted in the EU law and our constitution. So we may say that this is the restoration of the status in line with Constitution, Article 178 or 45. Constitutionally, we cannot maintain the status where the justice is dealt with by persons who are not judges. It's not possible. That would be really a violation, a permanent violation of the Constitution. So we may not agree to the fact that people who are not judges perform functions of the justice system. And indeed, I would agree with you with regard to the fact that we should be more precise as regards the issue of 2-year secondments and competence of the President of the Supreme Court. So against the background of our jurisprudence, I mean the Court of Justice. So I think here the criteria should be really very precise with regard to the decision taken by the President of the Appeal Court. But I understand that at the moment there is no clear legal basis for that, for that possibility. So as for the comment made by professor as regards damages or compensation, it goes very far. Article 12.4. Well, this is for a topic for a separate discussion. We may discuss it in length. So although I think that the system in theory is correct and well created, I mean the appeal path, but it doesn't function well. Unfortunately, in practice it doesn't function, but it's a completely different topic for a different discussion. Thank you so much. Thank you so much, Professor. Yes, Professor Mikuli. Well, I will be brief. I, of course, know the arguments as Professor Safian presented by the Helsinki Foundation, by Dr. Szwed and Mr. Płaszkiewicz, my colleague. So, as I've said, I am skeptical as regards individual solutions, and I'm more attached to Justitia's draft. Of course, everything must be discussed. Well, as for the issues of competencies, so all bodies of the Polish state should really exercise judgments within their competences. So these judgments of ECHRE and the CJEU, and the same, of course, does have the power to create abstract and normative acts here. So, but the basis for acting, in addition to Article 2 about the democratic state of rule of law, it would be also Article about the fact that Poland is bound by international law, that is international jurisprudence as well. As for the differences between, let's say, neo-judges in 2 chambers of the Supreme Court and neo-judges in other courts, I would be in favor of Professor Safian's view that as for the Supreme Court judges, it's an automatic solution, but probably we'll have to regulate based on the law the issue of neo-judges in other courts. There was a question about excluding the possibility of challenging. The professor already answered the question that here it is included, it is foreseen in the draft law, but I do realize that we are skeptical about it because we know in what conditions it was introduced and who really profited from that, but excluding the way of appeal would be disputable based on the Constitution. Thank you. Thank you so much. So we are coming to an end of this panel. So thank you, panelists, for very interesting speeches. We'd like also to thank for the questions put by the participants in the conference. So all these comments about the draft bill would be analyzed in detail by us. Of course, it is the draft, so this is the basis for further debates and considerations, soon legal considerations. So thank you so much for your participation in the first part of the conference. And once again, I'd like to thank the panelists for giving their very interesting speeches.